Please call the list.
Sir, may I be permitted to mention one matter for correction in your lordship's order? Lordships, if this matter was heard by your lordships, it was disposed of. Now, my lord, our claim for regularization was in the post of LDC cum typist. But while the order was being recorded, inadvertently the word cum typist has not
No, I have consciously done this.
My lord,
Sorry,
my lord.
sorry, I have consciously done this.
But my lord, our submission
No,
was
no,
this.
no.
My lord, may I submit?
Sorry, yes,
My lord,
yes, I remember. Yes,
my lord,
why you are
one minute,
mentioning?
Lordships, kindly, 1 minute, my lord, because our
Sorry, I have passed order. Sorry, yes.
Transport Department matter, lordship. Lordship.
Why you are mentioning today? Today is not the mentioning date. Mention on Monday.
My lord,
Why you are mentioning?
my lord, if it is not heard in this February, this writ petition will be infractuous.
Why?
Because petitioner has given examination West Bengal Judiciary preliminary exam 2023, but she got 80 marks, but she got more marks. She filed this. She applied for application to the representation to the authority, but they did not give any answer. My lord, March.
She wants more marks.
She knows she got more marks, at least 4 and 5.
So let it be there.
No,
It is
in the March main exam will be held.
maybe.
My lord,
Maybe it's not an urgent. Everybody who appears before the examination wants that she should be granted more marks.
in the
You
March.
have to wait. Sorry. If I find that ultimately your writ petition needs to be allowed, then I will pass an appropriate order. Yes, please call the list.
submission was cum clerk. Now,
Yes,
the
yes, yes.
submission is
Yes.
amounting to an admission, my lord.
Please, please call the list. Item number 1.
Lordships, may kindly appreciate.
No, sorry. Yes, please call the list.
One matter for the petitioner matter with matter that is
Just a minute. Yes.
that on Monday your lordship passed an order on the similar point.
Oh, similar matter, and that matter was also appearing in the list.
Yes, no matter that order has been already been uploaded and your lordship. The report has been filed here also, my lord.
It says DNS with marked right side, but report says nasal septum mild deviation to the left side. Let same order be passed. I have passed.
My lord, may I submit the kind of?
No, I have not called for any report.
Acha.
I have not called for any reports in similar matter. It's a case of mild DNS, as AIMS Kolani has medical board has opined that mild DNS left. In the review medical examination, it is said marked DNS with marked right side airway obstruction.
Yes, ma'am.
But medical board of AIMS Kolani said that mild DNS left with normal mucosa with bilateral nasal airway patency and no features of sinusitis. Airway patency, bilateral nasal airway is patent. All three passes are clear. And this report was provided to you?
Yes, my lord.
Yes.
My lord, only one
না, দাঁড়াও, আমি দেখে নিই, বলছি।
only one point, my lord, that They said my Kolani AIMS report says that
Yes. What does it
says
say?
that there is every possibility that candidate has taken treatment for nasal congestion and airway obstruction before undergoing examination.
Yes.
Before undergoing examination, before the said board.
Wait.
In the
Which
last,
part of it?
page 2 of the report, last paragraph.
No,
B.
report is dated 24th December 2025. I am on this report.
Hmm.
Which part you are relying upon? ENT examination, there is an heading. Under the ENT examination, see the findings.
Since the finding.
See the findings. All findings are indicative of mild DNS, and mild DNS is permissible under the rules.
At my lord, yes, my lord. Only the marked right way of obstruction is present also.
Where?
In her
From the
case.
report?
In the para 2, please first page.
Instruction.
Para-
No, this is the report.
Oh, acha, it is our instruction report.
This is the report. Your instruction will not do
Acha,
because
acha.
independent medical
Okay, my
body,
lord, okay.
independent medical body has opined the
My
report.
lord, my lord.
Has opined
Acha,
upon examining the petitioner.
acha,
I have not called for report in this matter.
acha.
It is for your consumption.
Yes, my lord. Understood, my lord. এই রিপোর্ট আমরা নিলাম।
Relevant clauses are 7.1, 7.1, and which would go against the petitioner is clause C 3D in case of marked DNS.
In case of mark. And
Is
obstruction of, yeah.
disposed of. Next.
Get put.
এটা দেখে করে দেবে একদম। Next.
Grateful, my lord.
I have recorded your submission based on review medical examination.
My lord.
Item number 2.
Item number 2, my lord, is my petition.
Actually, before my learned friend starts, actually the medical tests were conducted by the BSF. BSF has not been included. Could they just complete the BSF so I could get, if your lordships was not, nah,
BSF might have
SSC could
done it,
have,
but
but the record like, for it, to do, the verification for it, reconciliation. নাহলে ওরা
records are not there.
হ্যাঁ, নাহলে কি SSC it takes a long time.
The RAB BSF has done, but
Let the BSF authorities be made parties.
recruitment
And then you amend the cost title.
No, the recruitment is done by the SSC, there is no doubt about that. But lots
Medical test.
are conducted,
Everybody is doing this.
because otherwise it becomes, the whole process becomes much more complicated.
my lord, I will also.
Leave is granted to the learned advocate representing the petitioner to amend the cost title of the writ petition and array authorities of BSF authorities as additional respondents in course of this day. Stop. Such amendment is directed, such amendment of cost title is directed to be made based on submission made by the learned advocate representing Union of India that concerned BSF authority medically examine the petitioner for appointment in the post of Constable GD under Central Armed Police Forces. Stop. Next paragraph. However, service of notice upon additional respondents is dispensed with since Union of India is represented by learned advocate. Next paragraph. List the matter under the same heading on 10th March 2026. Stop. Learned advocate representing Union of India is directed to
Lordship, could your lordship keep it on the 11th, 9th and 10th, it'll be a bit difficult.
11th March 2026. Stop. Learned advocate representing Union of India is directed to obtain instructions.
May I be allowed to file a supplementary?
Why?
Because this.
Not at this stage. First, you amend the cost title.
I'm telling you.
Next. Item number 3.
Yeah, I am appearing on behalf of the state.
I appear for Millard, the petition. Millard, the petitioner for your lordship, Millard was the of the health department.
You are appearing for the state.
Statement.
Millard, I obtained a caste certificate from the authority, and this was done, Millard, upon giving a public hearing. And
Upon?
Public hearing by the protection safety. That was duly done and it was. My father, Millard, I have a full blood sister, younger sister. My father died in 29. My father died in 29. My younger sister, Millard, had made a complaint to the authority that the certificate, Millard, that was granted for me, Millard, that was equal to fraud and misuse. The authority, Millard, had decided the issue and Millard, it stood in my favor, said no, it is all. Then Millard, my younger sister, Millard, did not stop the journey endeavor. She again made a complaint to the authority after 2 years. Let's see, these are the anomalies. Kindly look into it. The authority did not do anything. He again approached Millard, your lordship's court. Your lordship's court, Millard, directed Millard, the authority to reconsider the issue. Then the authority, Millard, had come to that. Did not come to the finding that it is a fraud, misrepresentation, simply cancel.
Cancel the.
Yes. I preferred an appeal before the DA because this order of cancellation was never communicated to me. The appellate authority.
Behind your back, it was cancelled.
Yes. Number, the termination order, the authority, the moment it was cancelled, they referred it to the Millard, the health department, my employer. Employer, Millard, had terminated my service. You go to clause 3, Millard, which says that.
Then Mr. Basu, at whose complaint this has been done, she needs to be made party.
We have made her party before the DM. Appeal is
But in the writ petition, she should be made party. Court wants to hear her.
not just ঠিকই বলছে।
Old practice of Mr. Vasu. So, amend the cost title and make her party, serve notice, come back. I'm fixing it. Yes. Yes, because she made lost the complaint. Yes, the affidavit of service. Yes, affidavit of service filed on behalf of the petitioner. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Client advocate for the petitioner is granted leave to amend the cost title and add the sister of the petitioner,
Yes.
Sister, younger
or sole sister,
Yes, ma'am.
own sister or
Yes.
step sister,
Yes, ma'am.
own sister,
Yes, my lord. Younger sister.
and add the complainant being younger sister of the petitioner as additional respondent in course of this deed. Stop. After such amendment, after amendment is made, learned advocate for the petitioner is directed to serve notice enclosing copy of the amended writ petition and order passed today upon the additional respondent by 10 days from date and file further affidavit of service on the next date. Next paragraph lists the matter under the same heading on on 13th April 20, no, April. No. 25 আজকে, 25 very well on 11th March 2026. Next.
Lordship, kindly, 11 March, there is a the problem, Lordship. His marriage
Yes.
ceremony will be held on 11 March.
11 March. Sixteenth. Very well on
March, Lordship.
18th March.
Item number 4.
Commissioner Malad, I have instruction not to proceed with the matter any.
Not to place the matter.
Yes, my lord, not to proceed with it.
My lord, appearing for the respondents, my lord.
Issue. At the time of call, learned advocate representing the petitioner submits that that petitioner does not want to proceed with the matter, and in support of same, letter dated 23rd February 2026, which the learned advocate and in support of same, letter dated 23rd February 2026 of the petitioner is placed before this court, and same is taken on record. Next paragraph. Union of India is represented by learned advocate. Next paragraph. In view of the submission made on behalf of the petitioner, writ petition stands dismissed on the ground of non-prosecution. Stop parties to act on the server copy. Next.
Item number 5.
I'm the state respondent. Before my learned friend opens his case, I have got the primordial objection about the maintainability of this writ petition. Maintainability of this writ petition, my lord. So far, which has not been raised. Either before the other. Reporter.
Yes, why it is not maintainable?
Because he is a contractual employee. I have got the report, my lord.
Contractual employment writ petition is not maintainable.
No, no.
Why?
He's not coming within Article 12, well, you're not even
Yes, let's see
309.
this.
May I just indicate?
Lord, may I submit the report? Your lordship will browse over the lines of my report.
Lordship, can you take from the last order?
187.
Yes, my lord.
Show me that documents were supplied to the petitioner. Page 188.
188.
Second paragraph.
Instant matter.
Matter is being heard today. The petitioner is present today. The office of the CMOH South 24 Parganas forwarded the necessary documents for adjudication. Those documents were not supplied to the petitioner, and petitioner was terminated.
No, this is the
Caution letter has been.
Lord, and caution, Lord, regarding the caution letter,
Yes,
it is not a punitive in nature.
yes, but it's a warning based on certain documents.
It is not
The
a
petitioner was
punitive in nature.
censured. Petitioner was censured. It's a kind of warning. Now, why an employee is to be warned unnecessarily
Your lordship,
before granting opportunity to the petitioner to present his case?
let me then read out the impugned order which is under challenge.
Yes.
Let me read out. Let me read out, my lord. Which is under challenge.
Two documents, two parts I'm just indicating.
That is,
Just a minute. Yes, yes.
One is paragraph 2, what your lordship has I have placed on the earlier petition, and there has been, he has relied upon in the order on a mass petition. That was also never forwarded to me. These are the two things. I am not aware of what document the CMOH has forwarded and what is the mass petition. These are the two things, my lord. And the order is based on that.
Caution letter dated 29th April is not an election at all.
And there are some incorrect finding which I will indicate.
Just a minute.
Paragraph 4, my lord, at page 1.
Just a minute. So you are referring, you are submitting that the documents as referred to in page 120 subparagraph F, that inquiry report. That inquiry report dated 10th March 2025 and the further complaints against the petitioner. Against the petitioner.
Inquiry report
And further complaints against the petitioner.
Inquiry report I have got. Lordship, can you consider? Inquiry. But I am on 2 points, my lord. One, page 188, they refer to documents submitted by the CMOH.
The guidance of yes, yes, yes. What are those documents?
Well, I am not aware of it. One, that is my first ground of challenge.
That is referred to in page 182, second paragraph.
No, 188, second paragraph.
Yes, 188, second paragraph.
Second paragraph. I am not aware what are those documents which are. And second is the mass petition, my lord. And second.
Where from you are getting that there was a mass petition?
My lord, page 189.
Yes.
Paragraph 4, my lord. Unless the above a mass petition from villagers residing near Gutiara Sharif BPHC has also been received. The petitioner.
Yes, yes.
My lord, can you see? This paragraph 2. Petitioner submitted the following documents, copy of the representation. Representation belongs to him. Whether it has been submitted to us or not.
Come to page 188, second paragraph.
No, let me read out the whole.
Not read out. You please come to page 188, second paragraph.
I'm reading it out.
The second paragraph is a longest order, you need not read it. The instant matter is being heard today. Petitioner is present today. Office of CMOH Southern Parganas forwarded necessary documents for adjudication. What are those documents?
That is, the petitioner submitted the following documents. These two, next paragraph.
No, necessary documents. The petitioner submitted the following documents. It is petitioner's documents.
Submitted, yes,
but
submitted.
CMOH forwarded. Next paragraph is the petitioner submitted following documents. To that extent, there is
that is one representation.
That is not quarrel. There is no quarrel. Problem is this: the office of the CMOH South 24 Parganas forwarded necessary documents for adjudication. What are those documents? And in page 189, come to paragraph 4.
Four. Unless the above
A mass petition, a mass petition from
the villagers
residing near so and so has
Putiari,
also
sorry.
been received. The petitioner outlines certain the petition outlines certain irregular activities involving the petitioner that are socially unacceptable, raising further concerns about her conduct. So this mass petition needs to be served upon the petitioner before conducting hearing in order to grant adequate opportunity to the petitioner to present his case.
1 minute, brother. Not my junior says that in the inquiry report, it is there. It has been
Inquiry report, it is
he has got it. That has been served on him.
if after inquiry, when the inquiry report is prepared, it is there, that will not serve the purpose. Because inquiry is based on hearing. Inquiry report is based on hearing. Inquiry report is prepared after hearing. So if before hearing, these documents are not supplied to the petitioner, and relying upon those documents, adverse decision is taken against the petitioner, then petitioner gets affected.
Not the impugned order.
Think about.
I am
one thing,
thinking it. I am thinking
that the disciplinary authority is proceeding against an employee. It's not hypothetically, I am saying the disciplinary authority is proceeding against employee X. Now there are 3-4 documents which from the management side is placed before the authority against the employee. Now, if those documents are not supplied to the employee concerned, then how employee will be able to present his case before the disciplinary authority in support of his case that he is innocent?
Now the order
after inquiry report is prepared and along with the inquiry report, this is served. Before that, that stage is over.
No, before that, Lord, I submit, Lord, your Lordship, kindly the order under challenge impugned order, that is at page 140. Page 140, your Lordship, kindly see. Kindly see that. Page 29, 4th, 25. Issuance of caution letter. Caution letter is nothing, not is in punitive in nature. He has been cautioned because of the
authority can issue caution letter without initiating proceeding. Show me the provision.
The inquiry has been conducted.
Yes, if you conduct an inquiry, that inquiry has to be conducted in accordance with law, following principle of natural justice. Because the outcome of the inquiry may not be a grave punishment, may not be a major punishment. Outcome of the inquiry may be caution, may be censure. But if an inquiry is to be conducted, that is to be conducted in accordance with law and following the principle of natural justice.
Only the thing, the mass
Inquiry may be
petition
culminated into an order which is not a punishment order.
Yes,
but a warning was sounded to the petitioner. Now, even if for the purpose of sounding warning or giving warning or censuring a petitioner, you need to follow the procedure. So in that procedure,
that's true.
In that procedure, the authority is required to follow the principle of natural justice.
Not in that.
One fine warning employer can issue warning to an employee.
Not in that even.
According to the please wait. According to the sweet will of the employer. No,
certainly not.
Certainly not. So before giving a warning, employer is required to initiate a proceeding. Now, if it is a case of initiation of proceeding,
that is the service rule. That is the service rule.
Employer is required to follow principle of natural justice.
Not one thing.
This order is hit by principle of natural justice.
Not humbly, I beseech your Lordship. He is not governed by his own contractual employee.
But you have initiated a proceeding.
That is the wrong.
That is the very. For how many years this employee is working?
Not
how many years this employee is working?
Contractual.
Tell
if
me
after
how
1
many
year,
years this
if
tell me how many years this employee is
if
working.
he after 1 year his
Yes,
contractual
for
is,
13 years he is
but
working.
he is not, he has been become permanent.
Rightly done. A
He has not
proceeding is-
become permanent, my
a
lord.
proceeding is required to be initiated.
My lord,
Certainly.
inquiry has
Who
to be
says so
initiated.
that the proceeding is not
Lord, the
required to be
inquiry has to
initiated?
be initiated under what rule?
Now, this order cannot
Under
survive.
what rule, my lord? Your Lordship, I want,
But
for
that
my
is not an
education, I
issue.
want to know.
That
For
is
my
not an-
education, I want to know.
That is not an issue before this court today. Proceeding was initiated. In the report, in the final order of warning, it appears that certain documents are relied upon. Those documents are not supplied to the petitioner. Let these documents be supplied and you initiate fresh proceedings if it is decided.
Not the service rule. If your Lordship kindly allow me to submit. The service rule.
Yes.
This hearing was given pursuant to a direction of this Honorable High Court.
That point, the point of maintainability was not raised at that time. Your Lordship kindly see that.
Writ petition is certainly maintainable.
Not the contractual employee. He is not governed by
He
any.
is working for 13 years. What is the latest?
He has
Supreme
to be
Court
governed
judgment?
by any rules, my lord. Neither West Bengal service rule.
Not an issue today.
Then
That chapter, if that part is closed,
then the
so please don't dilate on this point. That is not an issue.
Not your-
Whether the question is, have you supplied these documents or not?
Lord, I am to learn from your Lordship. I want to
Whether
know.
you have supplied these documents or not. Have you supplied? If you can show me that you have supplied these documents.
We'll take the instruction out of the your
So,
Lordship.
last occasion, specifically, this point was put, this question was put to the learned advocate representing the state. Again, court will not grant
But
time.
not one thing, I
Yes, yes.
humbly beseech your Lordship. Since he
There
is
is
not
the
a
order of the
permanent employee.
previous order of the court.
My lord, page 185, your lordship. The order of the debate. My lord, I went to CAT. That rejected it, saying that I'm a contractual employee. I preferred an appeal. Division bench did not interfere. But gave me a right of hearing. Your lordship will kindly come to page 185, paragraph
Just a
4.
minute.
PN4.
Division bench. Fourth paragraph.
করে দিচ্ছি আমরা প্লেস অফ হিয়ারিং ওখানে পাঠিয়ে দিন ওখানে উনি তো কনসার্ন অথরিটি
Program officer.
সমস্ত ডকুমেন্ট সেনাকে সার্ভ করতে ফ্রেশ প্রসিডিং আবার করতে সমস্ত ডকুমেন্ট নেই তো সমস্যা ডকুমেন্ট আমরা দিই এখন আমরা ডকুমেন্ট গুলো সবার কাছে ট্রান্সফার দিয়ে দিচ্ছি দিয়ে তারপর আবার করে ফ্রেশ হিয়ারিং হবে স্পেশাল
Division bench has said so.
What division bench said, my lord?
Stigma is attached, granted leave to raise a representative.
Yes, paragraph 4. Paragraph 4. I've seen that. Paragraph 4. Paragraph 3 and start. We are informed the program officer. I have seen it.
In respect of the petitioner, a contractual employee having regard to the stigma attached to the caution letter dated 29th April 2025. In respect of the petitioner, a contractual employee, we call upon the learned state council as to who is the higher authority before whom the petitioner may vent his grievance. We are informed that program officer so-and-so is the authority. We grant liberty petitioner to raise a grievance regarding caution letter dated 29th April 2025 before the program officer. Now the grievance was raised and that was taken into consideration and this order was passed on 18 September 2025 without following the procedure?
Lord, may I submit? Keeping my submission, the point of mental unity.
Today you cannot take because you did not
I have
prefer an appeal against the order of
yes,
the
yes, that was
division
the
bench. That chapter
that
is
was the
over.
mistake. That part
That
has
chapter
gone.
is over. Today, since
That-
it is in spite of this order was passed, you did not prefer appeal before the Supreme Court against this order of the division.
That was a mistake on the part of the state.
So
state
therefore, you
plan
can prefer an appeal. But today, I am bound by the order of the division bench. Today, that point is not available to you
the
by
wrong
the
can,
in view of the order passed by the division bench.
the wrong can be perpetuated.
No, it is not a case of wrong. This order of the division,
particularly
this
point.
order of the honorable division bench has attained finality. After that, you are stopped from taking this
Right,
point before
right.
this
I
court.
bow down to my.
So you could
I
have
bow down to my.
you could have preferred an appeal before the Supreme Court that is a case of contractual employee. So therefore, this order is not warranted.
That point was not raised.
Now
One
you
thing-
cannot. So now you cannot take up this point before this court.
That was a mistake on the part of
That
the learned.
point is not available to you. Now the situation is this, that there are certain documents which were relied upon by the authority while considering the grievance of the petitioner. Now, whether those documents were supplied to the
Let
petitioner,
him, Lord, I suggest let him give a fresh hearing. Your Lordship kindly
that is
direct.
what court is saying. Why we are taking so much time?
No, Lord, I must say, at the last time, before the division bench, my learned friends who appeared for the state, they should have raised point.
আজকে কি আসেনি শিবু কি আসেনি মনে হচ্ছে matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. In the writ petition, order dated 18 September 2025, issued by Program Officer Roman Capital 1, National Health Mission and Senior Deputy Secretary to the Government of West Bengal, Health and Family Welfare Department.
No.
Being respondent number 9 is questioned. Stop. Learned advocate representing the petitioner submits that steps were taken by the respondent number 9 in terms of the order of the Honorable Division Bench dated 11th August 2025, passed on a writ petition being WPST 172 of 2025. Which was filed by the petition, or which was preferred by the petitioner. Stop. As per leave granted by the as per liberty granted by the Honorable Division Bench in the order dated 11th August 2025, petitioner raised grievance against before the respondent number 9 against letter dated 29th April 2025, and a hearing was conducted. Thereafter, impugned order was passed on 18 September 2025. Stop. By impugned order, caution letter dated 29th April 2025 was virtually affirmed. Stop. It is contended on behalf of the petitioner that Chief Medical Officer of Health, South 24 Parganas forwarded necessary documents for adjudication as recorded in the order dated 18 September 2025, and a mass petition of villagers were relied upon by the respondent number 9, but those documents were not supplied to the petitioner before hearing. Stop. It is submitted that due to non-supply of aforesaid documents relied upon by the respondent number 9 while passing impugned order dated 18 September 2025 prejudiced the petitioner. Next paragraph, state respondents are represented by learned advocates who has opposed this writ petition based on order dated 18 September 2025 of the respondent number 9. Stop. It is submitted that since petitioner is a contractual employee, writ petition is not maintainable. Stop. Next paragraph. Whether writ petition is now the point of maintainability of writ petition at this stage need not be delved into, as in terms of the order of the Honorable Division Bench dated 11th August 2025, respondent number 9 initiated proceeding on receiving representation from the petitioner and passed an order on 18 September 2025, which is under challenge. Stop. Relevant part of the order of the Honorable Division Bench dated 11th August 2025 is quoted below. এটা পেজ 185 এ পেয়ে যাবেন, এইখান থেকে এই অবধি কোট করে সেট আউট। হ্যাঁ, তুললে মামলা শেষ হয়ে যায়। বিশ্বগত বসু মল্লিক কত বড় ভাইয়া, সে তুললই না। Where is your representation? My representation. এখানে লিস্ট নেই, হ্যাঁ লিস্ট নেই। Not annexed.
It is not annexed.
It is not annexed to this.
On which date you prefer representation?
The representation 21/8/2025.
Where you have stated?
That is mentioned in the impugned order itself. At page 188, the petitioner submits the following document: a copy of the representation dated 21/8/2025.
I was under the impression.
In terms of the aforesaid directions, in terms of the aforesaid order of the Honorable Division Bench dated 11th August 2025, petitioner made a representation on 21st August 2025. Stop. Petitioner was granted an opportunity of hearing by the respondent number 9 and order was passed on 18 September 2025. Stop. On perusal of the said order dated 18 September 2025, it appears that while affirming the previous letter dated 29th April, previous caution letter dated 29th April 2025, respondent number 9 relied upon documents which were forwarded by the Chief Medical Officer of Health South 24 Parganas and a mass petition. Stop. However, these documents were not supplied to the petitioner before conducting hearing. Stop. It is settled. It is tried that the authority, before passing an order which is adverse to the interest of the employee, is required to supply documents which are relied upon in the proceeding initiated against the said employee. Stop. As next paragraph. Nothing is demonstrated on behalf of the state respondents that these documents or those documents were supplied to the petitioner before holding or before conducting hearing. Next paragraph. In view of aforesaid flaw, order dated 18 September 2025 stands set aside. Next paragraph. However, stands set aside. Stop. Respondent number 9 is directed to supply all relevant documents to the petitioner by fortnight from the date of communication of this order.
Not because of the elections, all the state officers are very busy. Election is knocking at the door.
Very well, you supply the documents and then you take any, I am just granting liberty by fortnight from the date of communication of this order, or by 4 weeks from the date of communication of this order. Stop. Thereafter, concerned respondent authority shall be at liberty to initiate proceeding against the petitioner afresh in accordance with.
Lord, your lordship is granting any time for initiation of proceeding? Nothing. Only supply within 1 month.
Till that period, they are not going to take caution letter.
Caution letters, it is not a punitive in nature.
No caution letter, no question of any further caution letter. I have set it aside. Yes, next. In anticipation, no order can be passed. Item number 6.
Matter for the petitioner led by Mr. D.N. Mitru. Last of my lord was directed to.
Lord, I appear on governing state respondents. Lord,
Just a minute. No. Service filed on. Yeah. Yes.
Lord, I have taken instructions, my lord. My instruction is this, my lord. The grievance of the deputy is that his name has been featured in the draft petition list, but not in the actual promotional list. My instruction says, my lord, that, my lord, in terms of two government memoranda, and, my lord, wherein a rule has been framed, my lord, the rule is called, my lord, West Bengal Services Recruitment Record Supply Rules. It says, my lord, the same employees of the group D staffs, they are to be considered for filling up the post of record supplier. But in that below Bardwan Medical College, there is no sanctioned post of record supplier. Although his name has been featured in the draft gradation list, since there is no sanctioned post of record supplier in that medical college.
Whether this draft gradation list was prepared covering all the government hospitals.
Oh, yes.
All the government hospitals.
All the government hospitals.
So, in terms of seniority, petitioner is eligible to be promoted to the next higher post, that is record supplier grade 1. But in Bardhaman Medical College, there is no post of record supplier grade 1.
Sanctioned post of record supplier grade 1. That's the difficulty. That's why his name didn't feature in the promotional list.
But in that event, petitioner will be superseded by his juniors.
Yes, my lord. And you see, my lord, page 20.
Well, that point has not been taken, but
yes. It's a point which needs consideration.
Yes.
If the juniors, juniors steal a march,
he made a
over the petitioner.
Yes.
In that event, petitioner will be superseded.
That is a very pertinent point, my lord. But, my lord, since he has made a representation to that effect, my lord, and on that same date, when the representation has been filed, on the same date, this petition has been filed. So we didn't get any scope to, my lord, consider his representation.
They will consider his representation come back by 7 days.
7 days, my lord.
Yes. Consider his representation. I'll permit you to consider his representation and come back. What is the outcome of consideration of representation?
My lord, yes, but my
And
lord,
I will direct the authority that while considering his representation, seniority should be given, seniority of the petitioner to be considered accordingly.
yes, but since there is no post, sanctioned post of the
Then you
record
have to
supply.
make an alternative arrangement. Transfer the petitioner to the neighboring district where the post is available. If it is not possible to create post in Badwan Medical
Yes,
College,
yes, there is no sanctioned
that
post,
is
my lord.
record supply grade 1.
Yes,
In that even send the petitioner to the neighboring district hospital.
my lord, I will take instruction, my lord. And also, my lord, whether
Because
he
the
is
admitted position as it appears, Mr. Mitra, from your submission,
lordship, my lord.
that petitioner is senior to some of the candidates
Yes, yes.
who have been favored with promotion to the next higher post, that is record supplier grade 1. Then why petitioner will be superseded?
The candidate name was considered, my lord, in the Badwan University. Kindly see, my lord, page 27.
Page 27.
They are junior.
Yes, page 26 is the draft gradation list.
Page 27.
Page 27. Yes.
Page serial number, my lord, 9.
9.
Page 27.
9.
Just a minute. Just a minute.
Well, I don't have page 27.
Date of
Eight
joining.
petition. Well,
Serial number 9. Then
95 appointment.
9. Serial number 9. Then
my lord, 11. Then 18.
Then
11. Then 18.
18. All are junior to junior.
All are junior.
Then
Well, I don't have that page, my lord.
come to page 27.
Well, I don't have page 27 in my representation. Just now.
Please give a copy to him.
Yes, yes, just
Copy
now.
of page 27.
Yes, yes.
Yes, he is submitting
Yes.
that the candidates against serial number 9, 11 and 18.
Yes.
They are from Bardhaman Medical College, Purva Bardhaman.
Lordship.
Current place of posting. And it is stated that following 21. He is promoted to the post of record supplier basic grade. So how juniors are promoted to Bardhaman Medical College? And you are saying there are no posts?
That is my written instruction, brother.
But that is not correct as it appears.
But I
When the petitioner was appointed as in the feeder post,
My lord, page.
General duty attendant.
Page 14, my lord, first appointment.
Page 14.
My lord. Page 14, first paragraph. Here the appointment was 9.
Just a minute. So he was appointed with a memo dated 27 July 1990. When you joined the post?
That day, my 94, my appointment was confirmed. Next page, page 50.
Confirmed. Yes, he was then appointed, he was confirmed on 27 July 1993 and initial appointment 27 July 1990. In case of others, three others,
1995.
1995, then 2007, then 2013.
Lordship, my lord.
How it is, it can be permitted? Petitioner is junior to all the three others who have been promoted to the post of record supplier grade 1.
Lord, I will check it up and get back to your lordship.
Otherwise, I will cancel this promotional order. Mr. Mitro. It appears that violating the
Or,
seniority
Lord, what has found from your lordship that, Lord, he has sent a representation
No,
in view of the lordship's
it's not a
order.
question of consideration of
No,
representation.
in view of your lordship's observation, we would consider it, taking all these, considering all these points, my lord. Considering all these points.
We will and come back. I will keep this petition pending
Lordship.
by 7 days.
No, not 7.
No.
Lord,
It's a injustice. Apparently, it appears
yes.
that is a injustice has been done to the petitioner. Without following the seniority, junior candidates have been favored with promotion.
Lord, they would consider his representation, my lord, in view of your lordship's, my lord, observation. And, my lord,
And if they fail to render justice to the petitioner, court will pass an appropriate order. Cancelling this
Let us
provisional
consider.
order so far Bardwan Medical College is concerned.
my lord, let us consider, my lord. And my lord, kindly give some time, my lord. My lord, next
So,
week.
Mr. Mitro, if I pass an order today granting leave to the authorities to take a decision, then it may create complication. So far the seniority point is concerned, that has been established before this court. Now I will simply adjourn the matter for fortnight to take necessary steps, not consideration of representation. If you can correct it or if you can accommodate the petitioner by promoting him accordingly, then court will pass an order. Otherwise, court has to take cognizance of the illegalities committed by the authorities.
Very well, my lord. My lord,
No further consideration of representation.
in view of your lordship's, my lord, observation, we would consider get back to your lordship, my lord.
In the meantime, my lord,
Fresh order will create difficulty.
in the meantime, my lord, one post vacant, my lord.
Yes, they have not joined.
My lord, we do not know whether they have joined or not, my lord.
Whether in the promotional posts candidates have joined. Because this is an order dated 16 January 2026. Promotional order is dated 16 January 2026. By that time, it must have been given effect to. Then let the authority take an appropriate steps. Why these three posts are, since these three posts are filled up, now you are submitting on instruction. You are submitting that no posts are lying vacant. But at the material point of time, these posts were there, Mr. Mitro. There were three posts. Why petitioner was not accommodated in terms of seniority? Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. It is submitted by the learned advocate. It is submitted on behalf of the petitioner. It is submitted on behalf of the petitioner that in the draft gradation list prepared by the concerned respondent authority for promotion to the post of record supplier within bracket grade 1 close bracket. Petitioner's name featured at serial number 6. Stop. But in the promotional order dated 16th January 2026, excluding name of the petitioner, 3 other junior candidates, namely Ramkrishna Saha, comma, Ishwar Doyal Prasad and Madhusudan Hajra. সেন্টেন্সটা কি বলছিলাম?
আমার একটা কমপ্লিট ডেফিনিশন দে, আমাকে অনেকগুলো
একটু answer।
প্যারাগ্রাফ নেই, ওই অ্যানেক্সচারটাই নেই
একটু
আমাদের
answer।
প্রমোশনের এটা। আরে কবে
Web decided to be promoted
এখন দে এ তো পাতাই নেই তো।
to the post of record supplier grade 1 within bracket grade 1.
আমি যে ওই পেজটা
So it is submitted
পাতাটাই নেই,
without following seniority.
তোরাই দিয়েছিস।
Promotion was denied to the petitioner as petitioner is senior to aforesaid
এখন দেখছি
3 candidates. Next paragraph,
নিশ্চিত নেই
placing reliance on
কোন কোনগুলো আছে। এই বিটটা আমার কাছে থাক, আমি তো জিজ্ঞেস করে আমি কথা বলবো।
confirmation order dated 24th January 1994. It is submitted that petitioner is working as
তো এখানে
general duty attendant within bracket GDA, being confirmed on and from 27 July 1993 and prior to that and initial appointment of the petitioner was 27 July 1990. Whereas একই সঙ্গে whereas Ramkrishna Saha joined the feeder post on 13th April 1995, comma, Ishwar Doyal Prasad joined on 20th November 2007 and Madhusudan Hajra joined on 13th November 2013. Stop. Next paragraph. In view of aforesaid submission and respective dates of joining of the petitioner and 3 other candidates, it transpires that junior candidates were promoted to the post of record supplier grade 1, ignoring seniority of the petitioner. Stop. Next paragraph. At this stage, Mr. Mitro, learned senior advocate representing
সিনিয়র গভর্নমেন্ট
senior government advocate representing state respondents, has prayed for accommodation which would enable the concerned respondent authorities to take necessary steps for promotion of the petition. Stop. Hearing of this matter stands adjourned for fortnight, which would permit the concerned respondent authorities to take necessary steps relating to promotion of the petitioner. Next paragraph, list the matter under the same heading for further consideration on March 19th, 2026.
দাদা আমি একটু জিজ্ঞেস করে আপনাকে দিয়ে দিই।
Item number 7.
We appear for the respondent number 6, my lord.
এগুলো আপনার নিয়ে নিচ্ছি, ফুল পেজটাই তো দেয়। No, no,
Why not? No, it will be on 19th.
Before my learned friend proceedings made, my lord, can I just indicate one thing? They have made the Union Bank as a party, whether the accounts belong to Punjab National Bank. There is a discrepancy in the cost.
Yes,
Kindly see the my lord, respond number 6.
6. Yes.
Admittedly, we are the releasing authority of the pension releasing authority, but with the Punjab National Bank, not the Union Bank of India. They have made by Union Bank of India.
The Union Bank sent us a letter. I immediately served the copy to the Punjab National Bank, and I have paid equally lordship to make Punjab National Bank as party. I have already
Pension releasing bank is Punjab National
Bank.
I have already served copy to the Punjab National
Copy
Bank.
served.
Pension account is opened with Punjab National Bank.
Yes.
So why you have made Union Bank as party?
Wrongly mistakenly I did it. The concerned bank give me a letter. I immediately send a copy.
You are
to the
representing
Punjab
Punjab National Bank.
Representing Punjab
So what is the matter about?
None of the matter relating to state government. And as your lordship already heard that the state government matter is here, and I am moving it petition. Because this is my epileptic service. And my lordship is the husband of the petitioner, was the pension holder under the Department of Public Health Engineering, Government of West Bengal. And after rendering continuous service, my lord, he received pension order in the year 2010. I have annexed P1 is the PQ.
Who received pension?
Husband of the petitioner.
When husband retired?
My husband retired, my lord, senior workman, he retired, and since 31st January 2010, he received pensionary benefit.
No, when he retired?
PQ, I'm sorry.
2010 minimum, 31st.
Yes, my lord, he retired on
31st
2010.
Date.
31st January 2010 retired. And thereafter he received pension. But subsequently, the husband died.
When died?
Around
2/6/2020.
2/6/2016.
2nd June 2016. Yes.
Since 3rd June 2016, I received pensionary benefit.
Wife is receiving pension.
Pension. Since 3rd January, 3rd
June 2016.
2016. All of a sudden, till June 2025, they are reducing my pension from 17,599 to 6,755.
From which date?
That is from June. From June. From the
June
month of
2025.
25. But I immediately made representation to all the authorities.
Yes.
No response. Subsequently, my lord, I sent a notice for demanding justice. No response. My lord, subsequently, I received a letter after filing this case. That is from the accounts officer. This letter is this. The accounts officer also said in this letter that he also did not know anything. There no communication has been made.
But I am for accounts officer.
This office.
Why the pension has been reduced? Family pension has been reduced.
But they are the disbursing authority. That is the, as per government order, my lord, all treasury officers of the state of West Bengal disbursing pension to the state government, pensioners or family pensioners have been authorized to pay pension or family pension. That is the existing pensioner or family pensioner at the consolidated rates.
Court wants to know that why the pension has been, family pension has been.
My lord,
Do you have any instruction that why?
My lord,
what is the reason for reduction?
My lord, kindly for a moment, my lord. Without any further authorization from the Accountant General
We have no
West
role to play.
Bengal,
We are releasing authority.
the Office of the Accountant General has no role to play regarding such consolation of family pension or in respect of such pensionary family pensions, my lord. They are the disbursing authority.
The question is, you are representing the state respondents.
No, my lord. She is.
You are representing Accountant General.
Yes, my lord.
Then he's the pension calculating authority. So why the pension has
My
been
lord,
reduced?
we are the authority to issue PPO, my lord.
Yes.
Yes, my lord.
So it's a pension calculating authority, auditing authority. Why pension has been reduced?
My lord.
What is called see the letter? Then it will be clear.
Yes, my lord. Later also with me, my lord.
Last 3 lines.
My lord, we received the letter from the petitioner.
Just a minute. You are representing state, then you have to apprise that you have to inform this court that why the pension has been reduced. But for that, why pension is to be reduced?
And not
Then I have to stop the salary of the treasury officer.
not only that, they have
Please
to
wait.
recovery.
Yes.
And due to some proper 90 family pension of the petitioner increase.
Technically, so pension will be really reduced.
And the meeting has been short for that.
Yes.
Meeting was been conducted by the treasury officer.
Meeting with whom?
The petitioner.
Petitioner. When it was conducted? Please read the instruction before doing the matter before the court.
My lord, can I?
Please wait.
My lord,
If you are not an responsible
Yes.
authority, please take your seat.
my lord.
You should read the instruction meticulously before appearing before the court, and don't waste court's time in this fashion. Tell me that why the pension was reduced, when the hearing was done, or when the meeting was conducted.
Conducted 6,025.
2nd June 2025. Don't say 2/6/2025. Yes.
And the second meeting, in that meeting, it was settled that the pension will be reduced to 5,000 rupees.
If it is not clear to you, then obtain further instruction and come back. Don't make submission on a point which is not clear to you. Mr. Mitra, appear along with her. And obtain instruction why the pension has been reduced. Family pension. Issue.
And then they also recovery was also started. I am saying recovery may be state.
No, not at this stage. Because in case of family pension, there are different calculations at different point of time. That I am not saying anything today. Let them come up. In case of family pensions, at different point of time, calculations may vary.
That is correct. But lordship knows.
Because the original pensioner may have opted. In that case, it will be enhanced. If it is a case of commutation, then it will be enhanced after some time, after 12 years.
But it has been reduced.
Now
and
it
then
is been
started.
reduced. Why it is to be reduced?
Recovery started.
Very well. Let it be recovered. Let them explain before this court that why it is reduced.
Lordship knows.
Unless until court is satisfied that recovery is improper, court will not pass any order. Yes. Petition affidavit of service. না আগে একটা করো. The writ petition is entertained.
Punjab National Bank.
মাসিদুল ইসলামের জাজমেন্টটা একটু দিয়ে দেবে তো. Writ petition is entertained in terms of the as it is decided in the judgment dated 13 January 2026, delivered in WPA 27327 of 2025, within bracket MD Masidul Islam versus State of West Bengal, that when benches under West Bengal Administrative Tribunal are not available, writ petition before this court is maintained. Next slide. Grievance of the petitioner being family pensioner is reduction of family pension from the month of July 2025. Month of July 2025. reduction of family pension abruptly in the month of July 2025. Top. From the submissions made on behalf of senior accounts officer, comma, accountant and accountant general senior accounts officer, Indian Audit and Accounts Department, Principal Accountant General within bracket A and E, West Bengal. সেন্টেন্সটা কি বলছিল? Being respondent number 3 and state respondents, it is not clear as to why family pension of the petitioner was reduced. Next paragraph. Mr. Shantanu Kumar Mitro, learned senior government advocate, is present in court, who is requested to appear on behalf of the state respondents. Stop. Office of the learned government period is requested to regularize engagement of Mr. Shantanu Kumar Mitro, learned advocate, on behalf of the state respondents. Next paragraph. Learned advocate for the state respondents is directed to obtain instruction as to why pension of the petitioner, family pension of the petitioner was reduced. Next paragraph. List the matter under the same heading for further consideration on March 2026. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cause title and describe respondent number 6 appropriately in course of this day.
Item 7.
Item number 8.
To appear on the state respondents, and for your lordship's kind assistance, I have prepared a report.
Yes.
This is the deficit code. আর একটা কোথায় গেল? ওখান থেকে দাও।
Yes.
That we were appointed as the health
ওটা না, ওটা অন্য
assistant
মামলা।
throughout the West Bengal, where we got appointment in 2024. Now, thereafter, we approached the High Court for transfer to our home district, which is the order passed by the High Court is at page 140. Now, pursuant to the order of the High Court, the recent order was passed, which is there in page 145, directly passed by the Director of Health Service, page 140. 147 is the operative part of the order. And pursuant to this order, the order of transfer, page 148 to 156 was issued. We have been transferred to our home districts. But accepting the petitioners before your lordship, all the 156%, they have been transferred to their home district. Barring these petitioners, they are in Murshidabad. The release order has been issued, page 156 to 160. Kindly have a look to the release order. In different districts, release order have been issued. Now, the fresh posting order has already been issued, appointing more than 800 health assistant female in different districts. But that is in 163. But we made a representation to the authority at page 236 that apart accepting these petitioners, 39 petitioners, all the 156%, in spite of the order release order issued by the Director of Health Service, but we have been the release order passed by the Director of Health Service, but we could not able to join our home district, but by the.
So you are not transferred.
We have not been transferred by the CMOH of the Murshidabad district. This is my prayer.
Lord, I have a detailed report for your lordship's kind perusal. Your lordship kindly have a look at it. First of all, Lord, they are not entitled to get promotion, transfer, because in view of the government circular, that is as annexure B, but last annexure, if your lordship kindly looks at. Kindly looks at, Lord, annexure B, Lord, clause 2 and 3, after completion of 3 years of uninterrupted satisfactory service. Just a minute, lordship, Lord. দেবো নিশ্চয়ই দেবো, যশোর বললেই দেবো, যখন আমি বানাবো কপি রিপোর্টিং দ্য ফর্মে তোমার দিয়ে দেবো। রিপোর্টটা কে দিয়েছে? আমাকে দিয়ে। না না বলছি সিওএমএইচ দিয়েছে। সিওএমএইচ পাবে, সব পাবে। আমরা এমনি রিপোর্ট Now, whether the petitioners have not completed a 3-year service, they have not yet to complete, Lord. That inspection I have, Lord, kindly sees apart from the circular to that effect.
But who has filed this report before your lordship? It is the CMO, Chief Medical Officer.
No, question is there is a circular to the effect relating to transfer.
That I tell your lordship.
Issued by the Director of Health Service, Government of West Bengal.
But my transfer order, kindly, I wanted to say something. But the High Court has directed the Director of Health Service to consider the case of home district transfer. This is the judgment of this.
But whether this circular was taken
Yes,
note of
yes.
in the order of the High Court.
Yes.
Show me.
That I tell your lordship. That
Show me.
Thereafter. But
That this transfer order was taken, it was considered
Yes.
by the court.
Yes. Page 142.
Yes. Transfer order কত? আগে অর্ডারটা পড়ি না। কত পেজ হবে?
140.
রিপ্রেজেন্টেশন করেছি। কোনটা বল? লিখেছি। দাগ দেওয়া আছে, হ্যাঁ। Just a minute. No, It's a mere consideration of direction for consideration of representation.
Was
But where is the consideration of this circular?
Lord, kindly,
Please wait.
Lordship.
Where is the consideration of this circular?
but this circular was taken care of by the Honorable Court. Now,
And that too when the tribunal was functioning.
no, at that point of time, there was window summer vacation. In the summer
So
vacation,
what? After summer vacation, tribunal would have been functional?
would have been. But may I? Now thereafter,
And where is the consideration of this circular, Mr. Bhattacharya?
in the reasoned order. In the reasoned order by the director.
By the court, where is the consideration of this
In the
circular?
writ petition, the judgment of the writ petition was the circular. On the basis of the circular, the writ petition was.
Very well, let me direct the concerned authority to consider the case of the petitioner in terms of the circular dated 29 January.
May I complete my sentence?
Yes,
May I?
yes.
Well, if your lordship kindly turns to the reasoned order. Well, I request your lordship to kindly see who has filed the report. The report has been filed by the Chief Medical Officer of Health.
Yes,
and who has issued the transfer order is the Director of Health Service, transferring us. Well, the Director of Health Service is a far above officer.
Yes, where is the consideration of report?
Yes.
Lord, kindly seize the order.
I am not on hegemony of the medical authorities, health directorate. You please come to the consideration order.
Page 146. Kindly
116.
Yes. First paragraph. And whereas it appears that the applicant joined the service as health assistant female after completion of the so-and-so course onwards on 21st of February 24, video appointment date so-and-so. This circular they are mentioned. 24.
Page 116 is a list.
146 is the reasoned order. And whereas middle portion
yes.
Second paragraph. And whereas is appeared. But got it?
Yes, yes.
But the report that has been placed before us, I don't have the copy, so I don't know what has been furnished before your lordship.
No, I am not on the report. I am only on the circular.
Circular dated?
Dated 29 January 2024.
29th of January.
Yes. Director of Health Services, Government of West Bengal.
Yes, that has been taken care of by this order. Madam, kindly have a look to first paragraph 2, then last but one paragraph.
Page 147.
146.
Just a minute.
Second last paragraph. শুভ একটা কপিটা দিয়ে আমি তো বুঝতেই পারছি
না এখন কপি দেওয়া যাবে না
কিন্তু তো সার্কুলার রিলাই করছি
কতটা
তোরা কি দেখাচ্ছি সেটা তো আমি বুঝতে পারছি না
ঠিক আছে যখন হবে দেখা
ওখানে রয়েছে তো সেটা বল আমাকে ডেটটা বল তোর লেখা রয়েছে ইনক্লুড অর্ডারের মধ্যে লেখা
কথা বল
দাদা একদম ভাব করো না প্লিজ
কিছু তো ভাব করুন না মুখে
Viral, you give a copy, go through it, I am coming there.
Yes.
My lord, item
Give
number.
a copy to Mr. Bhattacharya, let him go through it. এগুলো বসেছিল।
I'm at page 146. In the
Just a
recent order,
minute, no.
yes.
But this was not allowed.
No,
By order dated 2nd July to transfer was not allowed.
No, not at all. That is why I wanted to place it before you. Thereafter, kindly have a look to page 148, the release order. This order was passed on 2nd July 2024. The release order was passed, but practically after 1 year, 5 months. Page 148. I have got it, page 148.
Yes.
148 is the transfer order. After 1 year, 5 months.
But that is not in terms of the order passed by the coordinate bench or the order passed by the director.
But I am
Depends upon the posting and availability of vacancies. Then it was allowed.
But this was normal transfer. But I am before your lordship on the implementation of the transfer order.
But that how does it confer right upon the rest of the petitioners to pray for transfer when they have not completed 3 years of service?
I tell you, lordship. But this transfer order was issued on page 148. Can I have a look? 11th of December 2025. In the transfer order, page 149, serial number 25 is the petition number 1 before your lordship. But this transfer order has been given effect to by all the districts because this has been passed by the director himself, the Director of Health Service. He is the supreme authority. Page 156 onwards are the orders of release. Pursuant to this order has been acted upon by all the districts, excepting Murshidabad.
But not in similar manner. So come to page 152.
Yes.
In case of Dakshin Dinajpur, there are 2 transfers.
Yes.
In case of Malda, there are more than 10 transfers. So therefore, it depends upon the availability of vacancies.
I tell you, Lord.
And it's an administrative decision how the right is conferred upon you.
But I tell you, Lord. But 156, 150 repetitions were there in the repetition. Which was
show me that you have a right to get transferred. You are seeking mandamus from this court. Show me that you have a right to be transferred. Because by the order of the coordinate bench, nothing has been decided, only directed the director to take a decision.
True.
Director disallowed at that material point of time. Subsequently, transfer order was passed. It is the decision of the administrative authority.
Absolutely.
As to why the
but the CMO is writing a letter to
in case of Murshidabad, no transfer order was passed. It's a completely administrative decision.
But the CMO is a below rank officer. Kindly have a look to page paragraph 20 of the report. Well, I have taken a note of this report. Kindly have a look to page paragraph 20 of the last paragraph of the report. the CMOH has, by this report, the CMOH has presented.
No,
its
but
case.
in the order dated 11th transfer order dated 11 December 2025, which was issued by the Director of Health Service,
Yes.
no candidate from Murshidabad was selected or was decided to be transferred.
But the candidates from Murshidabad was there. Kindly have a look to serial number 1 onwards. Serial number 1 Murshidabad, 2 Murshidabad, 3
Yes.
Murshidabad.
So why you are saying that nobody from Murshidabad was transferred?
No, from these 2 blocks, only 2 blocks, Shuti and Shamsherganj, they have not been released. But the other persons have been released. And the other districts, Bankura.
See, why the petitioners are not released, others are released. That might be for the administrative reasons. But you have to independently make out your case that you have a right to get transferred. That appears that unless until you have completed 3 years of service, you do not have such right.
But the transfer order passed by the Supreme Authority. But I have a right.
No, this is also an order of the Director of Health Services.
True, but the director considering this order, released us.
Yes.
All the health districts of all the districts are following this. Only 2 blocks of Murshidabad, Shuti and Shamsherganj.
And all other female health assistants were transferred.
Yes, but yes,
all the female health assistants were transferred. Cannot be.
I have got the transfer orders. Can you have a look through?
Very well, Mr. Mitra, file a report in the form of affidavit.
My lord, if I may.
The release orders also I have annexed. Page 156 onwards. 157.
You will disclose that all the health assistants were transferred, excluding the petitioners, or some of the health assistants were transferred.
Some of the health assistants were transferred.
You will disclose in your
yes, and why they can't be transferred. That reason
and why
also there.
petitioners were not transferred.
That reason also is there.
That you will also disclose.
Yes, absolutely, madam.
Yes.
That's a file. File.
Petitioners, document is filed in support of putting in deficit court fees, and same is taken on record. Next paragraph, petitioners are female health assistants. আচ্ছা তার আগে দাও আচ্ছা একদম প্রথমে দাও the present writ petition is entertained in terms of the is entertained on placing reliance on the judgment of this court dated 13 January 2026 passed on WPA 27327 of 2025 within bracket Muhammad Masidul Islam and others versus State of West Bengal and others as benches under West Bengal Administrative Tribunal are not available. তারপরে যা বললাম তাই করুন. Next paragraph, petitioners are female health. ওই দুটো প্যারাগ্রাফ যেটা আগে বলে দিলাম, affidavit documents filed in support of the petitioners are female health assistants who are working in Murshidabad district, and grievance of the petitioners is though with a transfer order dated 11th February 2025 of the Director of Health Services, West Bengal. Female health assistants were transferred. Exclude other female health assistants of other female health assistants working in district of working in Murshidabad were transferred, excluding the petitioners. Stop. It is submitted that petitioners are also entitled to be transferred from Murshidabad to their respective home districts. Next paragraph, Mr. Mitro, learned senior government advocate representing the state respondents, relies upon circular dated 29 January 2024, issued by the Director of Health Service, Government of West Bengal, wherein it is provided that only after completion of 3 years uninterrupted and satisfactory service, female health assistants can be transferred. Stop. It is also submitted that petitioners have not completed 3 years service. Next paragraph. Taking note of the order dated 11th February 2025, issued by the Director of Health Services West Bengal, transferring 156 similarly circumstanced female health assistants to their home districts or to other districts. Concerned respondent authority. Concerned state respondent is directed to file a report in the form of affidavit disclosing as to why petitioners were not transferred. Stop. In the report, it will also be disclosed whether all the female health assistants, excluding petitioners, were transferred via order dated 11th December 2025 or not. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the heading motion on (25th March 2026).
25th
March. 3 weeks. By 3 weeks, he filed the report.
Yes. Grateful.
Next.
My lord, may I beg to appear for the petitioner?
Claim number 9.
My lord, may I beg to appear for the petitioner virtually, my lord? I tender my apology for not being present there physically, my lord. My lord, my case is identical to the previous one. I am the 157th unfortunate person. My lord, am I audible, my lord?
Yes.
My lord, I am appearing virtually, my lord.
Keep it with you. I have not called for any report. Yes.
My lord, I have been similarly placed. I am the 157th unfortunate individual, my lord, whose name is appearing in the transfer order as the previous case, my lord. My lord, I have been previously taken out an writ application, my lord, where a consideration order was passed, my lord, by a coordinate bench of this honorable court, my lord, subsequent to which, my lord, a reasoned order was passed. If your lordship kindly takes page 66 of that reasoned order.
Why petitioner was not transferred?
But he's not yet completed 2 years of service. So can I see the DO? So he has completed 3 years service.
Whether the others who are transferred all completed 3 years service?
No, none. None.
So why they were transferred?
The order passed by the team. Same authority orders passed, transferred. But as per the geodated.
If I may invite your lordship's kind attention.
Please wait. Yes.
Can see the paragraph 10 once well. And my lord, due to lack of staff, my lord, can see my lord, the reason for not being able to release my lord.
Paragraph 4.
Paragraph 10.
But this document, this is a circular. Which document you are relying upon? Paragraph 10 of the report. Paragraph 10 of this page report.
Paragraph 10, 11. Due to lack of
Just a minute.
10, 11, 12. 3.
But petitioner is transferred by order. Why that will not be given effect?
Can come 16 was.
I am asking you, petitioner was transferred by the order that is dated 146, number 1463, dated 11 December 2025.
Yes, Madam.
Why petitioner is not being released?
Lack of staff, calcium, 11, 12. It's clear, Madam.
11 December 2025, by which date you will be able to release the petitioner?
Madam,
Tell me.
CMA is not, if they get staff, they will. Only
So when you have taken a decision, then release her.
Yes, ma'am. So, madam, due to lack of staff, madam, that's the CMA.
But you have taken a decision to transfer her.
As per by the.
Where is the transfer order?
My lord, transfer order is appearing at page number 144, my lord.
Or page 16 normal.
Page number 144, my lord. (144), my lord. It is
serial number.
Serial number 29, my lord. My lord, I stand corrected, my lord. My name is appearing at page number 143, serial number 29, my lord.
Is also case of Murshidabad to Kuch Bihar.
My lord.
They have only 2 years of service. Or can see page 16.
That will not apply in this case. Here already a decision has been taken and petitioner has been decided to be transferred by order dated 11th December 2025. So therefore already director decided to transfer the petitioner.
This is contrary to the.
That point is not available to you today in view of the transfer order passed on 11 December 2025. So when petitioner you will be released? When petitioner will be released? When petitioner will be released?
As per the CMO, my lord, when they will get the staff, lack of staff.
After 5 years. Then when petitioner will be released? Tell me. We will come back, take instruction, come back.
The only reason that stated that lack of
petitioner.
I'm not telling no more. They have not complete 2 years of service.
Take it back. This is not for the report. This is a communication to you. Petitioner is working as female health assistant in Murshidabad, who has been transferred by order dated 11 December 2025 in memo number HNG, all capital, /3 capital P hyphen 20 hyphen 2017 /1463. From Murshidabad to Kuch Bihar. Stop. Grievance of the petitioner is, in spite of issuance of transfer order dated 11 December 2025, till date she has not been released. Petitioner prays for direction upon the concerned respondent authorities to release her as per transfer order dated 11 December 2025. Next paragraph. Learned advocate representing the state respondents has prayed for on next paragraph on posing query to the learned advocate representing the state respondents as to why petitioner is not being released in terms of the transfer order dated 11 December 2025. Accommodation is prayed for to obtain instruction. The hearing of this matter stands adjourned. List the matter under the same heading. On 11th March 2026. Stop. In the meantime, respondent authorities shall be at liberty to release the petitioner, which would permit her to join the transferred post in terms of transfer order dated 11 December 2025.
I'm filing the affidavit.
Yes.
Service file.
Affidavit service টা উপরে করে দাও, affidavit service filed on with আর ওইটাতে মাসিদুলটা করে দেব.
Much obliged, my lord. May I take your leave, my lord?
Item number 10.
Appear for the petition.
I am for the state authorities, Your Lord.
But I had worked continuously for almost 17 years as a contractual data entry operator. I remained absent for 1 year by reason of for 1 month.
Yes.
But although designated as a contractual data entry operator, I had rendered continuous service for about 17 years. But I remained absent for a period of 1 month roughly because of an alleged involvement in a criminal proceeding, a case which has got nothing to do with this employment. But on being enlarged on bail, I said I want to resume my duties. The authorities, as it appears from the tenor of their communication, they want to proceed against me in a departmental action. But either they have to place me under suspension and continue with the departmental action, or not they have to continue with the departmental action
without suspension.
Without suspension. This is kept hanging from September 2025. Now, please come.
Where is that page?
62, 64, and 65. These 3 pages in order.
Similar communication.
Yes.
So which one is the last?
Please come to 60,
which one is last?
62. 65. 64. 64.
Now, whether you were in custody?
Yes. I was enlarged on bail on 3rd of September 2025.
What are the charges?
The charges are not forging a document, misappropriation, cheating. Not all those things which had got nothing to do with this. And not even on the purport of that same allegation, but
will not be able to not justify. Not, please
Cheating
come
of
to
what? Cheating relation.
This is with regard to a security agency, which I had a license since 2005 maybe. Now, not the allegation made by the police officers is that I have been taking money for the purpose of giving them employment in my own establishment. But obviously, I will be taking service charges from the establishments. But that's completely different from the issue here. I'm a contract.
How long you were in custody?
31 days.
Then there is a deemed suspension.
No, they have not invoked this. That
is why it is deemed suspension. Even if it is not
Your
invoked,
Lordship, please come to page 65. They have not done so.
even if it is not invoked in the eye of law, you are suspended.
Had I been,
Unless and until Mr. Mujumdar it is formally revoked or you are permitted to join, how you can join?
A deemed suspension has to be recorded. It may not be communicated, but it has to be recorded. Now, please come to page 65. There's the decision.
Page 65.
Yes, probably that provision of CCS rule, that West Bengal service rules won't apply because I'm not holder of a civil post. Please come to paragraph 4. From 1/8/25.
Now, if you are not a holder of civil post and you are not appointed substantively, then is there any necessity to place you under suspension?
No reason. I say that they can either proceed against me in a departmental action without placing me under suspension, or they can allow me.
If you are temporarily working,
I have a
temporarily working, where is the requirement to initiate disciplinary
contractual
proceeding
period
against you?
which will expire on a particular date.
Where is the requirement to initiate proceeding against you?
Please come to page 65. Total number of days of absence 1/8/2025 to 8 September 2025. Total 37 days without any information. And on 8 September 20, the paragraph 4 at page 65. Has your Lordship got that?
Yes, what is your submission? How long this will
Your
continue?
Lordship's observation.
Yes?
No, I'm just helping her to give the documents.
Who?
She's appearing.
Your Lordship, I'm for the state authorities.
Yes.
Your Lordship,
How long this stalemate will continue? Either you
Your
initiate
Lordship,
or permit him to join.
he has been terminated, Your Lordship, by a resolution dated 16/2/26.
Where
He
is
has
that?
been terminated on a ground that is actually taking an advantage of dual appointment. Is also
Show me.
of my report, Your Lordship.
It is in the 32nd meeting of the HR Advisory Committee.
Yes, Your Lordship. 32nd meeting of HRSC committee.
16th February 2026.
Yes, Your Lordship.
Now, the consideration is this, that on careful scrutiny of all the existing documents received with reference to the above, it has been observed that the petitioner Snehasis Kumar is found to be working as a full-time executive assistant at uh, Bororongkua Rural Hospital, Nondigram, under National Health Mission. It has been found that petitioner is also working in MMYK Securities and Consultants Private Limited, which is an agency for supplying security service at the government hospitals within the district since 2024. So engagement of the petitioner in two different organizations. That's why relying upon a clause 2, it has been done. Now, this order, you have to file a fresh writ petition challenging this.
11th February, your lordship had heard this. And
16th February 2026. 16th February 2026. Yes, 11th February and then 16th February it has been done.
Yes, so please see.
A fresh cause of action takes steps, Mr. Supply a copy to him. Supply copy to the learned advocate representing the petitioner. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. And issue is pending from September 2025.
May I submit this? For the period from September 2025 till such time this order has been, or the decision might have been taken. I don't know whether this advisory committee can terminate or not. It may be an advice only. It might not have been fructified yet. So till such time, I'm entitled to not either a subsistence allowance or a salary.
Not
হসপিটালটা বলে ওটাতে তো আমি কাজ করছি, মন্দিরটা আমি কাজ করছি।
হ্যাঁ কি বলছিলাম on behalf of the না তার আগে করবে ওই সব জায়গায় করে দিচ্ছে আচ্ছা রিট পিটিশন ইজ এন্টারটেইনড in view is entertained placing reliance on the judgment of this court dated 13 January 2026 passed on a writ petition being WPA 27327 of 2025 MD Masidul Islam versus Masidul Islam versus State of West Bengal and others as benches under West Bengal Administrative Tribunal are not available. Next paragraph. During course of hearing, learned advocate appearing on learned advocate representing the state respondents appearing in virtual mode has submitted that petitioner has been terminated with immediate effect. Video order dated 16th February 2026 as per resolution of 32nd meeting of HR Advisory Committee within bracket HRAC. Stop. Next paragraph. In view of termination order dated 16th February 2026, in view of issuance of termination order dated 16th February 2026 against the petitioner, which is not under challenge in the present writ petition.
And it's being disclosed for the first time.
It appears which is not under challenge in the present writ petition, comma, validity and legality of the said termination order dated 16 February 2026 cannot be decided, cannot be delved into. Stop. However, it needs to be recorded herein that the writ petition was filed on
22nd January 2026.
On 22nd January 2026 and subsequent thereto, termination order was passed on 16th February 2026. Stop. Present writ petition stands disposed of. However, present writ petition stands dismissed, as in this writ petition, legality and validity of the termination order dated 16th February 2026 is not an issue. Next paragraph. However, this order shall not preclude the petitioner to take steps in accordance with law against order of termination dated 16th February 2026.
Or not kindly preserve the relief sought for in this petition also.
Yes.
I have paid for relief from the date of my expression of interest to resume duties. So not I may have a claim for that period.
Issues which are involved in this writ petition are also kept open.
But maybe have a copy of that communication.
Yes, sir, a copy. At a copy code at a record code the copy of the termination order dated 16 February 2026 is made over to the learned advocate representing the petition.
Grateful, Your Lordship.
Item number 11.
Wait.
Last occasion,
Direction.
small misunderstanding. Lord, I am appearing for the respondent 5 and 6 as well. Lord, last occasion 5 and 6 were not represented. Now I found that I am appearing for them also as well.
You have to directly me to serve
Yes.
upon them.
I have specifically asked.
Yes, Lordship.
But I did not get any reply.
Yes, Lordship.
So
That's
take this submission.
no. That's why
You may have
no.
instruction.
No. I personally told Lord that I was not representing. That was my misunderstanding.
Representing 5 and 7.
I am representing you. Well, then resignation has been accepted. His main allegation that resignation. Yes.
Yes. Then you have released the petitioner.
Yes, my lord.
Then your grievance stands.
Yes, also joined.
Join the post of assistant engineer in Panchayat and Rural Development Department. Issue. Learned advocate representing Sundarban Development Board has placed before this court order dated 19th February 2026, issued by Member Secretary and Project Director Sundarban Development Board. And same is taken on record. Stop. Next paragraph. From the said order dated 19th February 2026, it appears that resignation of the petitioner was accepted and petitioner was released to in order to facilitate him to join the post of junior engineer in Panchayat and Rural Development Department, Government of West Bengal. Next paragraph, learned advocate representing the petitioner submits that petitioner has joined the post of junior engineer, ঠিক আছে, in Panchayat and Rural Development Department today. Stop. Next paragraph, it appears that grievance of the petitioner stands repressed. Next paragraph, no further order need be passed on this writ petition. Stop. Writ petition stands disposed of. Every service to report it.
Item number 12. My lord, I am appearing on behalf of State Mine.
Petitioner asking for adjournment. He's having high fever, so he didn't come today. Kindly accommodate in the next week or so.
Without.
At the time of call, accommodation is paid for on behalf of the petitioner as the learned on behalf of the petitioner as learned advocate is unwell. However, state respondents are represented by learned advocates. Next paragraph, list the matter under the heading under the same heading in the monthly under the heading motion in the monthly combined list of April 2026.
It may oblige, my lord.
Next. Or এটা করে দাও in the monthly combined list of March 2026.
Item number 13.
Today,
I'm
my lord, I beg to appear, my lord, virtually, my lord.
I'm led by Mr. Mit Buhora. He is appearing virtual.
Yes.
My lord, am I audible, my lord?
Yes.
My lord, am I audible?
Yes.
My lord, I am appearing on behalf of the petitioner, my lord, appearing for the first time before your lordship. My lord, affidavit of service, my lord, be taken on record, my lord. The matter relates to, my lord, a pensionary benefit of a widow daughter, my lord, of the father who was an ex-employee of army, of airport, of army.
Army?
Yes, my lord.
Then you have to approach the tribunal.
Now, my lord, we
Armed
have
Forces Tribunal you have to approach.
My lord, we have sought for a representation, my lord, followed with a
No,
RTI.
but how this petition is maintainable before this court?
My lord, only what I beseech before lordship is, my lord, the application was preferred. That has not been dealt with, my lord. Only to
Whatever
that
may
extent.
be, today if court directs the authority to consider your representation that amounts to entertaining or writ petition, that is not permissible.
My lord, kindly takes my lord,
How
my
this
annexure, my
petition
lord.
is maintainable since you are to approach the Armed Forces Tribunal?
My lord, I have approached, my lord. I have made an application before the appropriate authority, my lord. That is the, my lord, kindly takes once, my lord, the running page number 23.
Yes, what is your instruction?
My lord, that is, my lord, this is not maintainable. If your lordship kindly sees page 28, my lord. His representation is ultimately that he has to approach the appropriate authority, my lord.
Yes, we have approached. We have approached. It is not the case that we have not approached, but we have, despite of we have approached, my lord, it has not been considered. That is the grievance of the writ petitioner, my lord. My lord, kindly takes, my lord, my application before the airport manager as well as the, my lord, the officer in charge of family pension on running page number 28. My lord, this representation has not been considered.
Issue. Affidavit of service filed on behalf of the petitioner is taken on records. Next paragraph. Petitioner has prayed for sanction of family pension being widowed daughter. Yes. কি বলছিলাম? Widowed daughter of an of a person who served in Indian Air Force as corporal, CORPORAL, and retired on 1st September 1978. Stop. As the petitioner is seeking family pension being widowed daughter in connection with the service rendered by her father, who was in Indian Air Force. Writ petition before this court is not maintainable. Stop. Petitioner is required to approach Armed Forces Tribunal. Stop. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to approach the tribunal on the self-same cause of action. Parties to act on the server copy. Next.
My lord, only my lord grants my lord liberty to approach my lord.
Next matter. Item number 40. Yes, I have granted liberty.
Grateful, my lord. I'm deeply
For the state, my lord.
I'm deeply honoured.
Lordship is my lord.
Sure.
Now, my lord, here, my lord, the petitioner participated in the recruitment of 2024 police recruitment constable, my lord.
Yes.
Police recruitment constable 2024, my lord, they have participated.
Process is already over, my lord, on 12th. I have the identical judgment passed by the coordinate bench on 18th February 2026, my lord.
Based my case, my lord.
Yes.
Now, my lord, what happened? my
Take it
lord,
out.
What happened is, my lord, in this physical measurement test, my lord, they passed written test. They passed in physical measurement test. In physical endurance test, my lord, efficiency test, my lord, the criteria is you have to run 1,600 meter in 6.30 minutes. 6 minutes 30 seconds. But that will be complete in 8 laps. In this, my lord, admit card, what has been followed from them is, my lord, they have run 7 laps, that too in 5.40 seconds. My respectful submission is, my lord, I have participated in a selection process, knowing fully well everything. I passed the written examination. I successfully passed in physical measurement test. Now in physical efficiency test, my lord, I have to complete 8 laps. I know that. And, my lord, curiously, my lord, it has been recorded that I have completed 7 laps, that too in 5 minutes 40 seconds. So 1 minute still left for me to complete the laps. There is no reason for me to withdraw from this, my lord. And I have made representations to them thereafter. Nothing has been done.
Which paragraph of this judgment?
7 laps in 1400 meter or 1600 meter completely correct.
My lord, petitioner was supposed to complete the 1600 meters within 8 minutes, 8 laps.
Yes, I have said that before, his lord.
He was incompetent and up to 7 laps, he did not perform, my lord.
7 laps, 5.40 seconds.
So what?
So what? So what?
That number means he
No,
has
no,
not time
certainly
to
not. You place everything
complete it.
that he has not completed 8 laps. How you say that?
He has admitted himself in writing.
Writing, you have taken everything before that. Everybody knows what is happening.
My lord, already on 12th February, process is completed, my lord.
7 laps এ 1600 মিটার কমপ্লিট করতে হবে 700 laps এ 1400 মিটার কমপ্লিট করেছে 7 laps এ 1600 মিটার কমপ্লিট করতে হবে he completed only 7 laps 8 laps এ 1600 7 laps আটটাই করতে হবে 7টা করলে হবে না এটা হচ্ছে সেম একটা অর্ডিনারি বাস
ছাড়ো
সেভেন লাখ হলে সেটা হবে না 8 লাখ হলে কমপ্লিট করতেই হবে
that is the minimum criteria.
যে মামলা এই যে সন্দীপ প্রামাণিকের যে মামলা এরকম সেম মামলা ইন্টারভিউ অর্ডার দিয়ে এদেরকে রাখার জন্য একটা আমাদের
থামুন আমি ওটাতে ঢুকবই না দাঁড়ান দেবো তো আগে আমাকে আমার স্লিপটা দিন
একটা কপি দিয়েছি একটু
আচ্ছা
Now, is there any provision for appeal?
No, my lord. My lord, please allow me to submit the instruction, my lord. Second page, my lord.
What does it say? This is for you, not for me. I have not called for an
The
instruction.
candidate, namely Sandeep Pramanik, who is the petitioner herein, my lord, appeared for physical efficiency test on 13th January 2026 under Bardhaman Range Recruitment Board, where he completed 13th January, my lord, where he completed 7 laps, that is 1400 meters race in 5 minutes, 44.477 seconds, instead of 8 laps, that is 1600 meters, my lord. I have given the opportunity for 1600 meters. I have given the opportunity for the time 6 minutes 30 seconds, but he did not comply, my lord. He did not complete it. That's not my fault, my lord. And already I have
all the petitioners could not complete that particular distance.
my lord, who has completed PET, to qualify for
I am
interview.
asking you, all the petitioners could not complete the running covering the requisite district.
Who are disqualified.
Requisite distance.
They are disqualified, my lord. Page 2, my lord. Paragraph number 5, bullet 1.
And problem is all the 6-7 petitioners,
Jugglery, my lord.
one writ petition, they are coming with the different cases. How how a joint petition is maintainable, Mr. Bosumonli?
I know, but they have
Because they have completely separate cases altogether in connection with their participation in physical efficiency test.
No, my lord, they all ran, my lord. They similarly, my lord, they have been disqualified on the same ground. Everyone has run 7 laps.
They have come to set criteria.
Same race, my lord.
এতজন ফিট
So why you could not complete 8 laps?
I have specifically said, my lord, in a letter also, my lord, that I complete within time. But they say,
How it is? Not at all, my lord. I object, my lord. Time was there for petitioner, but he did not complete it. My lord, that is the case. He is trying to divert the fact, my lord. My lord, there was 21,396 candidates who were found suitable, my lord, who were declared fit, my lord.
Not in
How many candidates?
21,396 were declared in PET examination, qualified.
Qualified physical
Efficiency test, my lord.
test. In the same range or in throughout West Bengal?
Throughout West Bengal, my lord. May I hand over the details, my lord?
Yes.
Fit, unfit, all are there, my lord.
সইও করেছে যে সন্দীপ প্রামাণিক সইও করেছে তো সিগনেচার কেন
21,396 candidates.
Those are qualified, my lord.
They'll come back tomorrow. Let it retain its position in the list. Record an order. Matter is heard in presence of the learned advocates. Heard in presence of the learned advocates representing the petitioners and state respondents. আচ্ছা উপরে করে দেবে ওই ইয়েটা মাসিদুল ইসলামের যে পয়েন্ট ইয়েটা করছি প্যারাগ্রাফটা দিয়ে যেটা করলে করে তারপরে করবে যে ডকুমেন্টস আর না তার আগে দেবে ডকুমেন্টস আর ফাইল document is filed in support of putting in deficit court fees. Stop. You are filing affidavit of service today. Affidavit of service filed on behalf of the petitioners is also taken on record. Next paragraph, matter is heard in presence of the learned advocates representing the petitioners and state respondents. Stop. Let the matter appear under the same heading on 26th February 2026 for further consideration.
Deeply obliged, madam. বলেছি স্টেট সাপোর্টে দিয়েছি
এটা রাখ second of original said matter should be taken up. So that's why tomorrow I have fixed. Otherwise this matter could continue.
Grateful, my lord.
My lord's kindly to mention year of 2023.
Yes.
I'm conscious, my lord, your lordship is not incorporating any hearing matter, but the fact remains, my lord, out of a same memorandum of a disciplinary of promotion, my lord, change of rule of game was challenged. The said writ petition was at my instance, but different writ petitioners. That was allowed by the coordinate bench. But identically situated petitioners have filed another writ petition. But no deep introspection is actually required. I will be placing the order.
Well, let it appear under the heading hearing. Let us see. Combined monthly list.
Grateful. Much.
I am for the statement.
I was seeking leave to file a supplementary affidavit. Lordship was pleased to grant a leave to me to an order passed in a petition being 33 of 2026. That was the pilot may kindly takes the that was from CPF to GPF. I prayer wish for conversion from CPF to GPF. ना कोई function में कितना अपनी तो
My lord will Transport Corporation.
Yes, my lord. My lord will kindly consider, my lord, on the last occasion, this is that matter wherein the petitioner, my lord, in one writ petition had prayed for the retirement benefits. The PF is remaining to be pending. On the other hand, my lord, the petitioner had made another writ petition praying for pensionary benefits. So there were contradictory claims, my lord. My lord had directed the petition, that writ petition was dismissed as withdrawn. And my lord had directed the petitioner to file a supplementary affidavit, which the petitioner has filed. My lord, I need to revert to the supplementary affidavit by filing an affidavit to it.
There's no direction or no leave was granted to file supplementary affidavit previously.
My lord, may kindly see the last page 40. Page 40.
There was no leave granted to file supplementary affidavit to the petition. Only Transport Corporation has prayed for opportunity to file an affidavit, and this affidavit is you are filing today.
My lord, that affidavit we are filing today. My lord, this supplementary affidavit is with regard to writ petition number 33 of 2025, my lord.
Your lordship will get in the supplementary affidavit page 40, your lordship's order, wherein the leave was granted to the petitioner.
Order date?
Order dated, my lord, that is
12th February, my lord.
11th February 2026.
11 February.
Supplementary affidavit page 40.
My lord, that is a different matter, my lord.
No.
Yes, it is WPO 810 of 2025.
Yes, in that writ petition, in 33 of 2026.
In that writ petition, there was no leave granted by this court to file supplementary affidavit.
Kindly see the next page 41 of the supplementary affidavit.
Tell me by which order you are granted leave to file supplementary affidavit.
Page 40 of the supplementary affidavit, 11th February 2026, in the WPO 33 of 2026. My lord granted leave to file supplementary affidavit.
In that writ petition?
In that writ petition, that was treated to be withdrawn, and leave was granted to file supplementary affidavit in this writ petition. Page 40. Kindly see page 41, paragraph 5.
That writ petition was dismissed as withdrawn.
Yes.
Because, my lord, two contradictory claims could not be made by the petitioner, my lord. On the
divergent cause of action, same cause of action, it relates to retirement benefit. So you may take appropriate steps by filing supplementary affidavit in the WPO 810.
Whether the matter is scheduled to come today. There is no such direction.
810 of 2025?
Yes.
Yes, my lord.
Yes,
Lordship
yes.
was directed on the order dated 11th of February.
Yes, 25th February.
Yes,
Yes, there was a leave granted in the writ petition.
Yes, my lord. My lord.
Another writ petition WPO 33.
Yes, my lord. Now, my lord, I need to revert to the, my lord, pleadings made in that writ
So you
petition.
want to file an affidavit dealing with the statements made in the
Supplementary affidavit.
And today you are filing an affidavit.
My lord,
Today you
yes,
file an
yes, I have filed an affidavit, my lord, with respect to WPO 810 of 2025.
Just a minute.
My lord, this is in connection with the PF.
Just a minute. It is in the form of report.
Report, my lord.
There are two reports.
One is by
Which
the
one
state-
you have filed today, which was affirmed on 23rd February 2026?
My lord, one report is filed by the state and one report is filed by
Your
on behalf
report
of.
was affirmed on 23rd February 2026.
My lord, will kindly give me. Yes, my lord, 23rd of February 2026.
Report filed on behalf of West Bengal Transport Corporation, which was affirmed on 23rd February 2026, is taken on record. Next paragraph, learned advocate representing the petitioner has filed a supplementary affidavit in terms of the leave granted by this court while dismissing another writ petition being WPO 33 of 2026. Video order dated 11th February 2026.
But not dismissed. I have withdrawn. You granted it withdrawn.
Yes, dismissed.
Dismissed as
Stop. In terms of the order dated 11th February 2026, passed in the writ petition being WPO 33 of 2026. Said writ petition was dismissed as withdrawn. Next, stop. Supplementary affidavit filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing West Bengal Transport Corporation has prayed for liberty to file an affidavit dealing with supplementary affidavit filed on behalf of the petitioner today. Next paragraph, let such affidavit be filed by 10 days from date. List the or let such affidavit be filed by 28 February.
My lord, 28 February. Huh?
Let such affidavit be filed by fortnight from date. Stop. List the matter under the same heading in the monthly combined list of April 2026. Yes.
This is a writ application and one state where they are asking for their provident fund.
Yes.
Whether West Bengal Transport Corporation has released or not. I have already released the amount. It is crystal clear. Why they did not?
But that issue is being considered by this court in another writ petition. Here it is a case where petitioner has filed two writ petitions. One seeking provident fund and another seeking pension. How two different and contradictory prayers can be made in two different writ petitions. Now, considering this aspect, one writ petition was dismissed as withdrawn based on submission made on behalf of the petitioner, granting leave to the petitioner to take steps in the writ petition being WPO 810 of 2025. Petitioner has filed a supplementary affidavit And now that is this court has granted leave to the land advocate for the Transport Corporation to file an affidavit dealing with. You are mixing up these matters along with another matter.
Deeply obliged, my lord.
What is appearing on his wife is not well and also he could not come. One day that
Record an order. At the time of call, accommodation is paid for on behalf of the petitioner, since on personal ground of the land advocate. So, however, respondents are represented by land advocates. Next paragraph list the matter under the same heading in the monthly combined list of April 2026. Is called item number 3. Item number 4. No, 3. Call item number 3. Item number 3. Same set of advocates, so far respondents are concerned.
In item number 3, same PFO is not the part.
But I am for the ECL. I am for the ECL.
In item number 3, you are appearing.
Item 3, I am not appearing. Item
So please take your seat. 2, you are appearing. Your name will be recorded. 3, only you are appearing for ECL. বুঝতে পেরেছো? 2 এর ক্ষেত্রে এরা দুজন, একজন হচ্ছে প্রভিডেন্ট ফান্ড অথরিটি আর একজন হচ্ছে ইসিএল, আর 3 এর ক্ষেত্রে only ECL is represented. তাহলে record an order. Same at a time of call, accommodation is paid for on behalf of the petitioner on the ground on the personal ground of the land advocate. Next paragraph, Eastern Coalfields Limited is represented by land advocate. Next paragraph lists the matter under the same heading in the monthly combined list of April 2026. Item 4.
My lord, on the last occasion, your lordship heard this matter.
Just a minute. Yes. What is your instruction?
My lord, my instruction is, since she has applied for monetary compensation after 22 years from the date of death of her father, this delay and latches, so far ECL is concerned, my lord, kindly appreciate. She is, ECL is not very willing to see with this petition. And my lord, being an
willing
officer
to-
of the court,
Willing to pay the monetary cash compensation.
as an officer of the court, my lord, I must show this order passed by Honorable Supreme Court, where this precisely same facts. My lord, kindly take a para 3, having regard to the fact that respondent had not applied to the appellant management
Last
for
3 years
seeking-
was paid in Dukni Bhuya. So pay last
Though-
3 years.
Though I have instruction to oppose, but since I'm an officer of the court first, then the mouthpiece of my client, now that is why I'm placing this order. I leave it to your lordship's kind consideration.
Yesterday also, I passed an order in similar. There was, after 25 years,
Yes.
dependent member came before this court, and I allowed 3 years monetary compensation along with current payment.
My lord, here,
I leave it to your lordship, but my instruction, what I,
here,
Dukni Bhuya, it has decided by the Supreme Court.
no, Supreme Court also decided that the monetary compensation has to be paid from the date of death.
It is
And-
applicable in this case.
No,
Because it is recorded, it is observed in paragraph 5 that in view of the said position, give a copy of this order.
What
In
is the
view
my
of
matter?
the said position, the impugned judgment dated 21st April 2022 passed by the division bench and judgment dated 16 November 2021 by the learned single judge are quashed and set aside. It is held that in the peculiar facts of the case, where the respondent waited for almost 21 years before approaching the court by filing the writ petition seeking monetary compensation from the appellant, the amount as directed to be paid by this court is adequate to meet the ends of justice.
3 years backward from the writ petition.
my lord, this order possibly is not applicable in the instant case. As to why, there are two things. First thing, my lord, this order was passed under the peculiar facts and circumstances. Second thing, my lord, this order was relied upon by the ECL in many of the cases. But the Honorable Division, even up to Supreme Court, has affirmed that the monetary compensation has to be paid from the date of death and with interest. And my lord, in this case, first time he applied.
The authority has provided appointment on compassionate ground to the petitioner, to the son of the applicant, the son of the deceased employee.
Now, if your lordship
He could not continue, and
They kept quiet for 10 years.
Not only this appointment was provided on 7 November 2001, and on 29th October 2010, he relinquished his claim over employment.
Now, my lord, if your
So
lordship
10 years lost by this time.
my lord,
So what prevented the petitioners to pray for monetary compensation just after the date?
but I have prayed for the employment. Kindly come page 50.
So employment was provided.
No.
Son was provided
Yes,
with employment.
thereafter, my client has, my lord, applied for employment. Now, kindly come page 54, my lord.
I have seen.
Kindly come. No, these two documents yesterday, my last day, my lord, I could not. My lord, kindly, my lord, see my lord, page 54, my
So
lord.
how from the date of death monetary compensation can be paid?
Let the-
Employee died in harness on 22nd May 1998, and on 7 November 2001, employment was provided to the son. Then son could not continue. Son relinquished his claim over employment on 29th of October 2010. So up to 10 you are not eligible.
Well, kindly come page 55, my lord.
Please answer the query
My-
of this
my
court.
lord.
55 will be considered later on.
My lord.
Please answer the query of the
My lord. Here, my lord, since the my lord, son has not been given employment.
Yes, he was given employment.
No, he was given, my lord, the appointment.
He locked the post for 10 years.
No.
And thereafter he said that no, give appointment to the daughter.
Well, he never joined. He never joined.
Yes, but appointment was given.
Appointment letter was given, but
Based
not,
on the application made by mother.
my lord.
So then,
Now, my lord, subsequently, my lord, they approved my employment.
not approved. It was processed, but some documents could not be filed. That's why it was.
That's why, my lord, I am praying kindly see, my lord, page 54, my lord.
And in this writ petition, you have not prayed for appointment of the petitioner on compassionate ground.
This judgment.
I have recorded in my previous order.
Yes, I am not praying.
So you are not you have not prayed for appointment.
I am not praying, but I am, my lord, I am relying the facts. Because this fact, Dukhni Bhuya, never applied for either employment nor monetary compensation. She waited 20 years to make an application for MMCC. Even no application was made for appointment. Here, my lord, page 55, kindly come. Page 55, this is their document, my lord. This is the medical examination conducted by them, page 54. Now kindly come next page, page 55. Right hand side, your lords will find this is the year of 2011, fit for job. If they would have provided employment in 2011, this question would not have been arise. Now kindly come page 61. Thereafter,
Just a minute, page 54, what is the date?
The next page, your lords will find in 2011, 20th May 2011.
Yes.
Now, my lord, page 61. Page 55, your lordship got, my lord, the fit for job observation is there in right hand side. Page 55, my lord.
Where is the medical report?
The medical.
Where is the report of the medical board?
The page, my lord, 54.
It's not a report of the, is it a report of the medical board?
Yes,
Medical
my lord. Kindly
examination
see, my lord.
form.
My lord, page 54, my lord. At top, my lord, pre-employment medical examination report.
Yes.
Lordship, my lord, got it, my lord?
Yes, what is no certificate submitted at the bottom?
No age proof.
Proof certificate submitted.
So they have assessed my age according to their, my lord, own procedure. Now kindly see at top, my lord, pre-employment medical examination. Now next page.
What is the signature of the medical experts?
Well, next page kindly come, my lord, page 55.
Yes.
Page 55, you also will find fit for job at right hand side. And signature of medical officer is there, date is also there. Now, if you also kindly come next, my lord, page at page 61. Even after medical examination, they again, my lord, send the matter before the screening committee. The medical examination of 2011 and this document of 2015, which, my lord, as appearing at page 61, at bottom, your lordship kindly see, as per the observation and recommendation of the unit and area screening committee, employment is recommended.
Page 61.
61. At bottom, my lord, kindly see. As per the observation and recommendation of the unit and area screening committee, employment is recommended to Sri such and such.
Yes.
Who have signed, my lord? Kindly see the general manager, who is my appointing authority, who has authorized, my lord, this, my lord, affidavit to be filed before your lordships, and chief manager personnel of the area.
Yes.
Now another document, kindly see at page 62, my lord.
Yes.
My lord, at your lordship will find, my lord, the members have signed here. Document I have given my type copy. Document in the employment claim have been found provided previously employment was offered by letter such and such, but due to the certain issues and physical inability, Sriram Maji was not agreed to accept employment. Thereafter, as per the recommendation of the competent authority, and there was pleased to process the employment claim of Sri Kumari Sukumani Mejan, daughter of late Atho. It appears that the relationship is genuine. Accordingly, it is recommended that the employment may be offered to Sri to Kumari Sukumani Mejan, unmarried daughter, such and such. So there was a clear-cut
So
recommendation.
why this appointment was not given? When
My
the
lord, kindly
petitioner
see
found
page
to-
63. Next page, page 63. She has not replied this letter till date.
No, I have given lot of my lord responses to them. Thereafter, my lord, kindly see, I have page.
Indemnity bond should be executed by executive magistrate. She has given indemnity bond notarized. That is annexed with this writ petition. Reason for delay. Certificates saying no MMCC against ex-employee is required. These 4 documents she has never ever provided.
If reason for delay in claiming employment is required, then why he was found to be fit?
My lord, she was found to be fit what? Medically.
Yes.
Medically, pre-employment medication means whether she is
Reason for
suffering
delay
from
was,
any disability or not.
Known to ECL.
But I cannot go
was
beyond
known
this
to his
document.
Brother was given appointment.
Absolutely, absolutely.
I could understand that after relinquishing claim over appointment by brother in October 29th October 2010, it was decided at the first instance by the ECL authority that no, once it was offered to the brother and brother could not continue, in that event you are not entitled to be considered for appointment on compulsion. But on the contrary, what ECL did, ECL processed the application for appointment on compassionate ground, and medical examination was held. In the medical examination, it was found that petitioner is fit, and thereafter on 11 January 2026, due to
Then screening test also done.
non-submission of certain documents, it was not given. At least you give monetary compensation from October 2010, because on 29th of October 2010, brother by writing a letter relinquished his claim. So from 1st of November 2010, you give.
My lord, kindly consider one aspect. She has never ever prayed for any monetary compensation till 26/12/2020.
But that is not required under the scheme.
But she has never applied.
She prayed for appointment. Appointment was not given.
Was not given, but she has never prayed for any compensation. ECL was not in a position to understand whether at all she or her family members had at all received MMCC or not. Because there are 4 family members.
Provision relating to NCWA 6.
No, there is no such provision explicitly written. Explicitly, there is no provision. But kindly appreciate one thing, what prompted her to apply for MMCC on 26/12/2020? That is only, I need this answer from Mr. Ghosh. What prompted her to keep quiet for 10 long years?
She felt that ultimately she is not going to be appointed.
My lord, she is not going to be appointed.
is not
We have
going to
never said so.
She felt that
We
no.
only asked
So
for
that's
4
why
documents.
as a second option, she applied.
But she has opted for second option after 4 long years, and then after 10 long years from the relinquishment of the employment.
Yes, sir.
Some interest may kindly be about.
Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields Limited, within bracket Phosphor ECL. Close bracket. Next paragraph, issue which needs to be considered in this petition is whether it needs to be considered needs to be considered whether petitioner is entitled to get monetary compensation, and from which date petitioner to be sanctioned monetary compensation by ECL due to untimely death of his father in harness on 22nd May 1998. Stop. Next paragraph. Father of the petitioner was an employee of ECL who died in harness on 22nd May 1998. Stop. After death of father, on application made by the on application made for appointment on compassionate ground, brother of the petitioner, namely Sriram Maji, was favored with appointment via letter dated 7th November 2001 under compassionate ground. Stop. However, brother of the petitioner could not could not serve under ECL, and finally, with a letter dated 29th October 2010, brother relinquished his claim over employment which was provided to him under compassionate ground. Stop. After stop. After relinquishment of claim by the brother, petitioner made an application for appointment on compassionate ground. Stop. Petitioner's application appears to have it appears that petitioner's application seeking appointment was processed by the concerned authority of ECL, and medical examination was conducted, as it appears from from a document which is at pages 54 and 55 of the writ petition. Stop. On medical examination, it was certified that petitioner was found to be, it was certified on 20 May 2011 that petitioner was fit to be appointed on compassionate ground. Stop. Furthermore, notice of this court has been drawn to a document dated 20 April 2015, which is at page 61 of the writ petition, wherefrom it appears that General Manager Pandaveshwar area, as well as Chief Manager within bracket personnel, Pandaveshwar area, recommended for appointment of the petitioner on compassionate ground. Stop. Ultimately, petitioner was not appointed, was not provided appointment on compassionate ground. Stop. Next paragraph. Mr. Krishnendu Bhattacharya, learned advocate representing ECL, has placed reliance on a letter dated 11 January 2016, issued by Assistant Manager within bracket personnel, close bracket, Kotta D Colliery, page যাবে, হ্যাঁ এটা page 63 লিখে রাখো, Kotta D Colliery, addressed to the petitioner, whereby petitioner was requested to submit certain documents. Stop. It is contended on behalf of ECL that documents which were required to be furnished by the petitioner as per said letter dated 11 January 2016 could not be furnished, as a result whereof final decision was not taken relating to appointment of the petitioner on compassionate ground. Stop. It is submitted that though the process was initiated for providing appointment of the petitioner on compassionate ground and medical examination was conducted, but subsequently the process could not be taken to logical conclusion, resulting in denial of appointment to the petitioner on compassionate ground. Next paragraph. Be that as it may, petitioner in this writ petition, court is considering entitlement of the petitioner to be entitlement of the petitioner to receive monetary compensation by ECL in terms of relevant provisions of National Coal Wage Agreement within bracket NCWA. Stop. It is provided under NCWA that due to death of employee in harness, a female dependent member of the deceased family is entitled to receive monetary monetary compensation. Stop. Question is from which date such compensation needs to be paid, taking note of the facts of the present case. Stop. Next paragraph. From the submissions made on behalf of the parties and materials available on record, petitioner was provided. Yes.
Kindly record the judgment that I have relied on.
Petitioner was provided. No, petitioner. Brother of the petitioner was provided with appointment on compassionate ground. Vide. Letter dated 7th November 2001. But brother could not continue his service and he was never paid salary by ECL. Stop. Ultimately, on 29th October 2010, brother of the petitioner relinquished his claim over employment, resulting in application made by the petitioner seeking appointment on compassionate ground. Though process was initiated by the concerned authority of ECL for providing appointment to the petitioner on compassionate ground, but the process could not be taken to logical conclusion, as a result whereof petitioner was not provided appointment. Stop. In next paragraph, in the aforesaid circumstances, in terms of relevant NCWA, petitioner is found to be eligible to receive monetary cash compensation. Stop. Next paragraph, it is stop. Regarding payment of arrear monetary cash compensation, reliance is placed on the judgment of the Honorable Supreme Court dated 13th October 2023, passed on special leave to appeal within bracket civil close bracket number 18815 of 2022 within bracket Messrs. Eastern Coalfields Limited and others versus Dukhni Bhuiya by the learned advocate representing the ECL. Stop. According to ECL, in terms of the ratio of Dukhni Bhuiya Supra, at best petitioner can be paid monetary compensation for a period of 3 years just prior to date of filing of this writ petition, not beyond that. Next paragraph. Present case needs to be considered based on the facts, based on the relevant facts, based on the relevant facts as narrated herein alone. Stop. Petitioner applied for appointment on compassionate ground after relinquishment of claim by his brother Vide, letter dated 29th October 2010. Stop. Application of the petitioner seeking appointment on compassionate ground was processed by the concerned authority of ECL, but ultimately petitioner could not be provided with petitioner could not be provided with appointment due to the reasons due to certain reasons. Stop. Therefore, it is not a case that petitioner did not make application either seeking appointment on compassionate ground or payment of monetary compensation after relinquishment of claim by the brother of the petitioner on 29th October 2010. Stop. In Dukhni Bhuiya Supra, it was recorded in paragraph 5. In paragraph 5, that respondent waited for almost 21 years before approaching the court by filing the writ petition. Stop. In the present case, though writ petition was not, though petitioner has not approached the court, but petitioner's application for petitioner made application seeking appointment on compassionate ground and which was processed Stop. Question would have been different had petitioner's application seeking appointment on compassionate ground was rejected at the first instance on the ground that previously appointment was offered to his brother. Stop. Even on 11 January 2016, concerned authority of ECL requested the petitioner to submit relevant documents for payment for her appointment on compassionate ground. Stop. Therefore, ratio of Dukni Bhuya Supra does not come in aid of ECL authorities, does not come in aid of ECL. Stop. It needs to be recorded herein that order passed in Dukni Bhuya Supra was in particular facts and circumstances. Stop. Next paragraph. In view of aforesaid aforesaid conspectus, concerned authority of ECL is directed to grant monetary compensation to the petitioner from 1st November 2010. From 1st November 2010 till date. As brother of the petitioner relinquished his claim over employment vide letter dated 29th October 2010. Stop. Concerned authority of ECL is directed to release arrear monetary compensation by 4 weeks from the date of communication of this order. However, claim of the petitioner seeking interest on arrear monetary compensation is rejected. Is rejected. Stop. Writ petition stands disposed of urgently.
And kindly direct them to start my lord, present, my lord. Present also may kindly monthly.
Petitioner shall also petitioner shall also be entitled to receive current monetary compensation, and same shall commence from the month of March 2026 onwards.
Only one prayer, my lord. If you also kindly record, if they do not pay by this time, then default interest may kindly be.
Default clause. Sorry.
My lord, can it be on April instead of March? Since authority has to take
from
certain
April
decisions.
20, then up to March you will get by way of arrear. Then from April, March to April 2026. এটা অর্ডার গুলো সমেত পাঠাবে।
For the state.
আমাদের বলা কিছু তোমাদেরই বলা for the state.
My lord, may I make a submission, my lord?
Yes.
My lord, this petitioner, my lord, this writ petition has been brought into the list by filing of a IA application, my lord. My lord, subject to correction, my lord, this IA application cannot be, my lord, taken into consideration, and the orders prayed for in the IA application cannot be passed without dealing with the merits of the writ petition, my lord, because the orders prayed in the IA application are the orders prayed, are the final relief prayed in the writ petition. So, my lord, this is a very clever way of bringing a matter which was appearing in hearing into the court of application by filing an application. Even the annexures are the same.
Fact requiring filing of interlocutory application.
May I just indicate to your lordship? If my lord may kindly comes to the order passed on page 26 and 27 of the supplementary of the GA application.
Page
26.
Yes, what is the prayer in that application? Let me see.
The application for the GA, as it stands, my lord, to pass an interim order.
What remains if
May-
this
may I just-
if this order if this prayer is allowed?
I am on a,
What remains to be decided in your writ
only on a
petition?
limited prayer. I am only on a limited prayer. My prayer is that the formal execution of agreement required for the purpose of renewal of my tenure.
Yes.
Formal execution of an agreement is required.
Where is the prayer to that extent in the in your application?
And only when pass an interim order to allow the petitioner to join the duty.
Yes. So what is the prayer for execution of the agreement?
My lord may kindly comes to, if my lord may kindly comes to, that prayer is not there. My lord, I can modify the prayer, my lord, before your lordship. May I just indicate?
Yes, everything can be done at a time of final hearing of the writ petition.
No, so far as this,
Interlocutory application, if there is a subsequent fact requiring approach, requiring the litigant to approach the court or the petitioner to approach the court,
subsequent fact
then an application is required to
but
be filed.
that subsequent fact arose after the order passed by the coordinate bench in this instant writ petition. My lord may kindly comes to the one. May I just indicate your lordship? My lord kindly comes to page 20. Page 20.
Yes, what is your instruction with regard to the renewal notice by the Howrah Depot?
My lord, the renewal cannot be made because of the writ petitioner himself. I am telling. My lord, the in the writ petition, my lord, this my lord will kindly comes to page 51 of the writ petition once.
If my lord may kindly comes to page 20.
Just a minute. Page 51.
Now, my lord, page 51 is an order which is passed by the managing director, which is dated 23rd May 2025. My lord will kindly comes to page 52. My lord, page 52 is the ordering portion where it is ordered that he may be given the chance to serve the corporation on production of valid driving license and execution of agreement as
Just a minute.
stipulated.
Yes, prayer for back wage was refused. But on production of relevant documents, petitioner may be permitted to.
I had no difficulty with that. But my lord will kindly comes to the prayer portion of the writ petition. The petitioner has sought for, my lord, setting aside of the entire order dated 23rd May 2025. So this part of the order is also joining of the petitioner, and the part of the order is dealing with the back wages. Now, when the entire order is under challenge, and in the writ petition there is no pleading as to as to a part cause of action is challenged, the entire order has been, my lord, alleged against in the writ petition. So, my lord, the order cannot be complied in part It is my order itself, so I cannot work on the order in part and cannot fight the other part of the order in court, where there is absolutely no pleading in the writ petition stating that the petitioner wishes to join and is only challenging the portion dealing with the refusal of back wages.
Work, then where is the question of wage? Payment of
Yes.
wage?
That I have been prevented. That is in the.
And that is going into the merit of the writ petition. Then we'll let
May
us.
I just indicate your lordship? If I've been interrupted, I won't be able to assist your lordship.
Prevented by whom?
I've been prevented by the organization in itself. Why I tell your lordship? But I am
Disputed question of fact.
that will,
How the writ court will decide.
but that will be adjudicated at the final hearing of the writ petition. So far as the writ petition is concerned, opposition has been given. I have filed reply. But so far as the interlocutory application before by way of J is concerned, my lord, I have got a limited prayer pursuant to the order passed by the department at page 52 on production of the valid license and execution of the agreement is concerned. So far as the valid license is concerned, that is at page 60 of the writ petition. And that license is valid up to 2035. Now, so far as the agreement is concerned, if my lord may kindly turns to page 55 once.
No, but if you have challenged the entire order dated 23rd May, 29th of May 2025, then how you will be permitted to join?
But
because it was decided by the managing director that page 52,
my lord,
the aforesaid fact that it is ordered that he may be given chance to serve the corporation on production of documents.
And there was no question, my lord, there was no question of passing any interim order. That is why affidavits were directed. And my lord, after the affidavits, my lord, this IA has been brought into effect.
If my lord may kindly comes to the order of the coordinate bench, my lord, the order of the past of the instant petition is 27 of the GA application.
Issue.
Page 26.
Issue. Application being GA1 of 2025 is taken up for consideration in presence of the learned advocates representing the petitioner, state respondents, and West Bengal Transport Corporation.
My lord, this is CSTC. Calcutta State
Transport Corporation. Within bracket for short CSTC ঠিকভাবে করবে যেখানটা বুঝতে পারবে না জিজ্ঞেস করবে তোমার ট্রান্সক্রিপশনে অনেক কারেকশন করতে হয় CSTC. Next paragraph. By filing the application being GA1 of 2025, applicant/petitioner has prayed for release of full salary, and permission and direction to join and direction which would permit the petitioner to resume duty. Stop. Next paragraph. Considering the prayer made in the writ petition, if application being GA1 of 2025 is allowed, in that event, if allowed, it would amount to disposal of the writ petition by granting final relief. Stop. It appears that petitioner has made an attempt to get the writ petition finally heard by filing application. Stop. Next paragraph. In aforesaid consideration, application being GA1 of 2025 is disposed of, directing the writ petition to appear in the list in the monthly combined list of April 2026 under the heading hearing. কাগজটা পাঠান তো জানতে কাগজ করে দিই। Yes, please call the next matter.
Eight, my lord, I appear for the respondents after the report and the exception being filed. This matter has come up, my lord. Like hearing, my lord, now it's.
This is a matter.
particular hearing.
It's ready for hearing.
Yes. Report and exceptions are filed.
Then let it appear under the heading hearing.
It will also be directed to be appear under the heading, my lord, court application.
Yes, now it is ready for hearing.
Or exception and
The last
reply, my lord.
occasion.
Court application.
Exception and reply, my lord. I am praying for only MMCC, my lord. The husband has died 2011.
He prayed for employment and MMCC both.
Very short issue involved, my lord. Neither employment nor MMCC has been paid. Though husband has died in, my lord, 2011.
An application made in 2022.
Please, what is the issue?
Issue, my lord, MMCC I am praying for from the date of death. Here, my lord, they have agreed to pay.
Issue.
But from the date of, my lord, application, not from the date of death. So if you lordship kindly
Report in the form of affidavit and exception and report in the form of affidavit is filed on behalf of Eastern Coalfields Limited, and an affidavit taking exception to this report has also been filed by the petitioner. Stop. Matter is found to be ready for hearing. Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2026. Next. At the time of call, no one appears for the petitioner and no accommodation is prayed for. In order to grant one more chance, hearing of this matter, one more chance to the petitioner, hearing of this matter stands adjourned. Likhchen to? Hearing of this matter stands adjourned. Next paragraph, list the matter under the same heading in the monthly combined list of April 2026.
Your Lordship, in item number
Time for the
4,
petition, madam.
Your Lordship, Ms. Tanushree Das Gupta is appearing for the Coal India, Your Lordship. She's on her legs before some other court, Your Lordship.
Not today.
Yes, Your Lordship.
All the appellate said matters. লিস্টটা সরিয়ে নাও, এটা একটা পার্ট ছেড়ে গেছে। ও এটা তো কম্বাইন্ড লিস্ট ধরবে না এখন, তাই তো?
হ্যাঁ ঠিক আছে ঠিক আছে
Item number 169 from monthly list of appellate side.
After filing this declaration, it's not died. And substitution has been filed.
Yes.
Substitution filed, substitution application.
But it is not on can one of 20 yes. When petitioner died.
Petitioner died on 30th September 2025. And my lord, petition filed. That was 18th August 2025.
30th September. Within time. Within 90 days.
Only legal. আচ্ছা দুটো
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. The next paragraph. Petitioner died on 30th September 2025. Application being can 1 of 2025 is taken out, seeking substitution of the applicant due to death of sole petitioner in the writ petition. It is submitted that applicant is major and sui juris. Stop. Next paragraph. Respondent is represented by learned. All the respondents you are representing.
In your opinion,
You are representing Port Trust.
Port.
Yes.
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 1 to 5.
Port
No,
Trust.
yes, all.
Port authorities. Shama Prasad Mukherjee.
Porters. Samples.
Port authorities are represented by learned advocate. Next paragraph. Application being can 1 of 2025 is allowed, thereby directing the department to substitute name of the legal heir of deceased petitioner, deceased writ petitioner in place in the cause title of the writ petition, in place and stead of the petitioner, in terms of paragraph 4 of the application by 7 days, by 10 days from date. শেষের পিটিশনারটা না রিট পিটিশনার। নেক্সট list the writ petition under the heading motion in the monthly combined list of April 2025. No, sorry.
Get.
Item number 170. Yes.
On behalf of the state.
I have applied for my lord absorption as home guards in the selection process as home guard in Howrah Rural District, in 2018.
What is the urgency that you are moving this court?
Lord, it is
Move the tribunal when the benches are available.
the thing
All
about
matters cannot be permitted to be moved before the High Court by transforming the High Court into a tribunal.
the point is very short. The point where
Whatever may be, you are seeking absorption when you are initially appointed.
Lord, I was not appointed. I was Lord, I was selected in 2018 itself. My name
Then-
came up in the selection process.
Then today you are moving this court before the High Court for seeking absorption
The reason has come up
when the tribunal is not there.
No, but the reason is obviously I was initially rejected because there was a criminal case going on against me, which has now been disposed of, with my acquittal. Hence, Lord, I make this representation to reconsider my case. Your Lordship kindly takes up page just
At the time when you filed this writ petition on 21st August 2025, tribunal was there.
tribunal was my lord, at that
Yes.
time.
Yes, yes,
in August it was there. My lord.
Tribunal was functioning at that
Up
point
to
of
September,
time.
the tribunal was available.
In September, it had gone.
Then how on the date of you filing this writ petition, it was maintainable before this court?
I had sought to my lord give an explanation that the tribunal, my lord, the dates are my lord,
Yes.
dates for hearing are fixed at my lord, long distance apart. That is the explanation I had sought to. In any case, I'll have to my lord, bow down to your lordship's my lord, observation in that regard. I have said that not equally efficacious.
Court can understand. It's a really urgent matter. Tribunal is not available. Court is ready to hear it. But all matters cannot be moved before this court since tribunal is not available. You are waiting from 2018 and now you are moving this High Court, and that too when the writ petition was filed, this tribunal was available. Why you filed this writ
It was
petition before the High Court?
My cause occurred in August itself. My lord, my cause first came.
Now situation is altered in your favor. But the situation was completely different at the time of filing of this writ petition.
My lord, the
Yes,
cause-
place your case. Let me see.
Cause has anything. If your lordship kindly takes a page 13 once, but I'll just take a very, I'll just briefly show
You are working as selected for the post of
for as for absorption as home guard.
Home Guard.
Home guard in Howrah Rural District. Your lordship kindly takes a page 13. Lord, may kindly find my name and serial number 7. Dr. Rajiv Mondal, that is the petition before your lordship. Now, thereafter, after this,
Nothing is readable. Page 13.
There are type copy, my lord. The next
After
page.
the type copy.
Hmm.
Oh, I'm sorry. But there is a type copy. I'm very sorry. Kindly pardon me. 13A is my type copy, my lord, at serial number.
Now you could not be appointed since you are involved in a criminal case.
Yes, a criminal case.
Now the criminal case is disposed of,
Disposed of with
acquitting
my
the petitioner.
Yes, if your lordship now kindly takes up the judgment starts at page 14. If your lordship kindly comes at page 22, that is the operative portion. At page 22, my lord, it is ordered, if I may read out, my lord. The accused persons namely such and such, 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 and thereafter the petitioner. And such and such two other persons found not guilty of committing the offence under section such and are hereby acquitted of the charge them against them as per section 248(1) of CRPC. Now, this order was passed. Your lordship will kindly find the order is in the very next page. The date of the order is 28/11/2023.
Now, since this criminal proceeding was pending, police report was not furnished.
Was not fine.
And now the situation is changed, and you are seeking appointment or engagement as home guard.
My lord, one thing is, my lord, it is a purely contractual service. Second
But
thing,
you are selected.
yes, selected, but subsequently, due to the, my lord, it is the
crime against the society. That's why, my lord.
There is an order of acquittal.
Now he is under acquittal. Whether in the meantime, whether there is a available vacancy or not, that should be considered, and thereafter, my lord, your lordship can direct
So
to
obtain instruction and come back. Obtain instruction and come back that why petitioner is not being appointed today. In view of order of acquittal dated 28 November 2023.
and subsequently he has made a representation on 5th January.
No consideration of representation. Why petitioner will not be considered for engagement? He is a selected candidate. Police verification report was not furnished since his involvement in criminal case. Now criminal case is culminated into an order of acquittal. Now there is no bar. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Present writ petition is entertained, placing reliance on the judgment dated 13 January 2026, passed on a writ petition being WPA 27327 of 2025, within bracket MD Masidul Islam versus State of West Bengal and others, as close bracket, as benches under West Bengal Administrative Tribunal are not available at present. Next paragraph, it is submitted by the learned advocate representing the petitioner that petitioner was selected for being engaged as home guard under Bengal Police.
Under Howrah Rural District. Howrah Rural Police.
Under Howrah Rural
District.
Which authority, which respondent?
Is not this indicated. No, I'm sorry. Comes under the West Bengal Police, but it is the absorption will be there under the Howrah Rural District.
In West Bengal Police, it is submitted that petitioner was to be engaged under the Superintendent of Police, Howrah Rural District. It is also contended that petitioner was selected based on a document at page 13 of the writ petition, wherefrom it appears that petitioner's name featured at serial number 7 in the list of selected candidates. Next paragraph, it is submitted that petitioner could not be engaged as home guard since police verification report was not provided due to entanglement of the petitioner in a criminal proceeding. However, the criminal case culminated into an order of acquittal, and judgment was delivered by the criminal court on 28 November 2023. So, it is submitted that now there is no impediment in engaging the petitioner as home guard. Next paragraph, Mr. Sushant Pal, learned advocate representing the state respondents, prays for accommodation to obtain instruction. So, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on. March 2026. Oh, this is from the combined list. Obtain instruction, list the matter under the same heading in the monthly combined list of April 2026.
At the top of the list.
Yes.
May I prefer
Once it is taken up, normally these matters are taken up in the next month from the next monthly list.
Item number 171.
Well, in this matter, I appear on behalf of the respondents.
Yes. Respondent, which respondent? State respondents?
No, my lord, Union of India. All the respondents.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, Union of India is represented by learned advocate. Next paragraph. It appears petitioner has lost interest. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, am I audible, my lord?
Number 172.
My lord, am I audible, my lord? My lord, am I audible, my lord?
Yes.
My lord, this matter is regarding, my lord, the affidavit of service is there, my lord, and we also informed the concerned state advocate also regarding the matter of today, and she.
When you are not noticed,
my lord?
you are representing state.
Yes, my lord. I am appearing on behalf of the state.
Yes.
My lord, may I continue, my lord?
Yes.
Yes, my lord, this is a matter regarding a compassionate appointment, my lord. There is this person late, Manoranjan late. He died as an upper division clerk in the ADSR Rampurhat in the March 2020, my lord. And subsequently, my lord, a particular application was made for a compassionate appointment of the son, my lord, in the June 2020, my lord. Now, subsequently, my lord. My lord?
Yes, sir. Rampurhat means?
Additional district sub-register, my lord.
Then why you are not moving the tribunal? Yes.
My lord, this is regarding a representation which we send. My lord, this is self-explanatory. May I continue for 1 minute, my lord?
You why you are not moving the tribunal?
My lord, it's not functioning, my lord.
But you filed it on 25th August 2025.
My lord, subsequent to that, my
Point
lord.
of time it was functioning.
My lord, actually, there is this, my lord, long delay, and we did not get any from 2020, my lord. We did not get any.
What were the court fees? There are two petitioners. You have deposited court fees of one petitioner.
My lord, this is my lord. If it is.
Sure.
My lord.
Learned advocate representing the petitioners is granted leave to file deficit court fees by 10 days from directed to deposit court fees by 7 days from date as it is found that at the time of filing the writ petition, court fee in respect of one petitioner was deposited. Next paragraph. State respondents are represented by learned advocate. Next paragraph. List the matter under the same heading in the monthly combined list of March 2026. Next.
Much obliged, my lord.
Item number 173.
Petitioner. Some people are paying for only 1 day's accommodation, my lord.
Why?
I missed the brief, my lord.
At the time of call, accommodation is paid for on behalf of the petitioner.
I appear for the respondent.
Which respondent?
Housing board, my lord. My lord, 3 to 6.
Respondent numbers 3 to 6 are represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of April 2026.
Grateful, your lordship.
Next.
Item number 174.
I beg to appear on behalf of all the respondents, Your Lordship.
Court being agreed with the non-grant of family pension behalf of the petitioners.
Yes.
For non-grant of family pension in behalf of his deceased husband, who is an employee of Railway Protection Force. What happened in this pattern? The petitioner.
Family pension is not paid.
Not granted. What is the story behind it? The petitioner got married in 1964. 1966, the petitioner, husband of the petitioner joined the force. After retirement, he got retirement after discharging 38 years of service on 2005. Subsequently, pension was granting monthly pension was granting to the petitioner's husband. Petitioner, husband of the petitioner died in 2025. But the petitioner approached the authorities, from where the petitioner came to learn that, pursuant to an order of this honorable court, the name of the petitioner was struck off from the PPO, inserting a name, namely Shefali Roy, who alleged to have been the first wife of the husband of the petitioner. But subsequently, pursuant to a memorandum was issued, pursuant to an order of this honorable court, and the name of the petitioner was struck off, and the name of the erstwhile wife was inserted. But the wife, the first wife, died in 2023, prior to the death of husband of the petitioner. And family pension had not started, but the PPO stands itself in the name of first wife, for which this petitioner is not getting the pension.
Because you are not eligible.
This petitioner,
Whether here the death appears to be immaterial, death of the first wife is immaterial. If you are not legally married wife of the employee, then you are not eligible.
the petitioner, all on can consider appreciate one thing,
First wife was there during the subsistence of first marriage. Second, the employee married for the second time. That marriage is not a valid marriage.
Petitioner was all along from 1964 was not aware of the marriage of the second wife, first wife. And if your lordship takes knows the rules, railway pension rules, if your lordship takes rules 75 of railway pension rules, may I just place once.
Issue. Matter is heard in presence of the learned advocates
Case of bigamy, your lordship.
Stop. Next paragraph. Petitioner prays for sanction of family pension. Sanction of family pension due to death of her husband, who was an employee, who was a member of Railway Protection Force. Next paragraph. It is submitted that first wife of the employee, first wife of the employee of or first wife of the member of the railway of the said member of Railway Protection Force was made nominee in connection with the service of the service of the said member of Railway Protection Force. Stop. It is further next paragraph. It is further contended that as the first wife died, therefore petitioner should be held eligible for receiving family pension. Next paragraph. Such submission. Next paragraph. Union of India is represented by learned advocate who has opposed this writ petition, and it is submitted that petitioner ought not to be petitioner may not be treated as legally married wife.
There is a divorced daughter or
Legally
the first wife.
Legally married wife of the deceased employee.
There is a
Stop. It is also submitted that there is a. It is also submitted that there is a daughter born out of
first marriage.
Born in first wedlock. For born in first wedlock. Stop. It is submitted that the daughter needs to be added as a party to this writ petition. Next paragraph. Learned advocate for the petitioner is directed to amend the cause title of this writ petition and add daughter of the deceased, daughter of the and add daughter who born in the first wedlock as additional respondent. Whether you are in a position to add her party in course of this day, or you want particulars of that particulars. So are you in a position to supply the particulars
No,
of the
lordship.
daughter?
We don't have any information.
We also don't have any. I believe
So where from you are saying that there is a daughter?
From there was a order. There was a divorce case and maintenance case. We found in the maintenance case there was a mention of a daughter. That a case of 94, your lordship. That
divorce case.
That Ranjit Roy, that constable, he filed a divorce case. Divorce case got dismissed for default.
Divorce case against the first wife.
First wife that got dismissed for default. There is no legal separation between the first
So
wife.
there was no dissolution of
There was
marriage.
a dissolution of marriage. Then the wife filed a maintenance case and further enhancement of maintenance case. From that order, we found there is a daughter. In 94 case, the order of 94, we found there is a daughter, but no trace of the daughter.
আচ্ছা তাহলে কি বলছিলাম দেখো তো?
But the department can find out definitely.
By fortnight from date. By fortnight from date, learned advocate for the learned advocate for Union of India is directed to supply the particulars of the daughter if same are available with the department. Stop. Next paragraph. After amendment of post title, learned advocate for the petitioner is directed to serve notice enclosing amended writ petition and copy of the order passed today upon the added respondent by fortnight thereafter, and file further affidavit of service on the next date. Next paragraph, list the matter under the same heading in the monthly combined list of April 2026. উপরে দিয়ে দাও,
I'm deeply obliged before your lordship.
petitioner is taken.
Item number 175.
My lord, on the last occasion, my lord.
Advocate
Who?
Devashish Kundu. Devashish Kundu is for the petitioner.
Where is he?
He has, due to personal inconvenience, unable to court.
He has not come to court.
No. He came but left the court.
At the time of call,
Let this affidavit in opposition be
at the time of call, accommodation is affidavit of
report, my lord. Report in the form of affidavit, my lord.
at the time of
I'm
call,
different.
accommodation is paid for on behalf of the petitioner on the ground of the learned advocate, on the personal ground of the learned advocate. However, Union of India is represented by learned advocate who has filed a report in the form of affidavit and same is taken on record. Next paragraph is the matter under the same heading in the monthly combined list of April 2025.
Much obliged.
File your report.
I filed, my lord.
Next.
Item number 176.
At the time of call, no one appears. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Writ petition stands dismissed for default. Parties to act on the server copy duly downloaded from the official website of this court. Next.
Item number 177.
Why it is appearing under the heading motion? 2011 writ petition.
It is for the final.
Hearing matter.
Yes, Your Lord.
Affidavits are complete.
Yes, Your Lord.
Affidavit in opposition and reply is there.
Yes, Your Lord.
Issue.
My lord, for the respondent, Mr. Parthasarathi Ghosh is appearing. My lord, he has some.
Perusal of record, it appears that video order dated 8 December 2011. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2025.
Item number 178.
Lordship, I appear for the petition in this matter.
Lord, I beg to appear for the state respondent, but not the answering, my lord, is State Warehousing Corporation.
Hearing matter.
No, what happened was, Lordship.
There's a writ petition of 2012.
Yes.
Yes.
This matter was appearing at the beginning, Lordship. Now in 2022, it was dismissed for default. In 2022, it was dismissed for default. There was an 11 days delay.
The writ petition was disposed of by
No,
order
that-
by
that
order
order was
dated 5th
recalled.
September 2022.
That order was recalled. Later on, my Lord Justice Ray said that it's not under my jurisdiction and nobody pointed out. So you should see the order there. That I am withdrawing my order because I don't have jurisdiction. It was pointed out later. There's another order repealing that order. Lordship, kindly see. This was first, the order was, the matter is disposed of.
Just a minute.
তাহলে আপনি এখানে চলুন।
Warehousing.
Then it was dismissed for default
Then
by
it was
another
dismissed
coordinate
for-
bench.
Then
31st October 2022.
Yes. Then, Lordship, the application for restoration was filed, but it was not moved. When the application for restoration was filed with a delay of 11 days, but it was not moved. Later on, Lordship, when I took over last year,
I found that the application for condonation of delay has not been prepared.
Who is representing State Warehousing Corporation?
Mr. Kambaleswar, appear for the whereas one matter is running. I'm praying for short pass.
I'm appearing for a state respondent.
No, today, Lordship, all I want is, because certain developments had taken place, I have the papers with me in 2013, 2014, which had not been incorporated. So unless a supplementary affidavit is brought out by me.
What are the developments?
Yes. Lordship, 3 letters were exchanged between the petitioner and West Bengal.
By representation, what petitioner is claiming?
Yes. For Lordship, there are 3 letters. One on 22nd July 2013. That was when the matter was there. Then there was a reply from the corporation on 29th January 2014, asking for certain details. Then again, we gave a letter in February 2014. Those are not there.
Whether the petitioner was an employee of respondent number 2.
Yes, West Bengal.
So what benefit is seeking?
Can I just hand over?
Tell me what benefits he is seeking.
He had gratuity, leave encashment, balance emoluments, traveling allowance bills, area ropa.
Retired.
He retired.
When retired?
It was a retirement in lieu of withdrawal of disciplinary proceeding. He retired on 2013. 2011 November. He retired in 2011 November. Now, when certain benefits were pending, the writ petition was filed. Now, after that,
then I have to hear the warehousing corporation. They are the main.
No, but if I bring out a supplementary.
No, not at this stage. At the time of call, accommodation is paid for on behalf of West Bengal State Warehousing Corporation. Stop. However, petitioner and state respondents, you are for the state. State respondents are represented by learned advocates. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of March 2026.
Also with the cost letter respondent number 1 is wrongly incorporated at PE and IR government. This is a food.
We'll come back on the next day. Next matter.
Item number 179.
Matter that I am appealing on behalf of the petitioner.
I
have paid for one indulgence, my lord. I am seeking, my lord, 1 week appeal.
Lord, in this matter, my lord, Mr. Anirban Mitra is appearing.
Hearing matter?
My lord, my lord, probably
is it a hearing matter?
Probably is not the hearing matter.
Let me
Because after checking, my lord, I have not found any direction for filing of appeal. It's pending since 2015, my lord.
Yes, there is a direction for filing affidavit in opposition. On the first date.
My lord, that is not.
By Justice Vishwanath Samantar as his lordship.
That is not in the service of therefore, my lord. A very interesting matter, my lord.
Yes.
Next day, my lord.
All matters are interesting. Issue. On perusal of at the time of call, accommodation is paid for on behalf of the petitioner. Stop. State. You are for the state.
No, my lord. Mr. Anirban Mitra is appearing on behalf of the respondent, my lord. Union of India. Union of India, my lord. Not state more.
CRPF. Union of India is represented by land advocate. Where is he?
My lord, he is did not come. My lord, he is not well today.
কিছু করার দরকার নেই। Accommodation is also paid for on behalf of Union of India. Next paragraph, on perusal of record, it appears video order dated 7th September 2015. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph, list the matter under the heading hearing in the monthly combined list of April 2026. Next.
Item number 180.
179 হলো সব মামলা মোশনে ঢুকে বসে। আর অন্য ম্যাটার রোজ মেনশন হচ্ছে, মোশন নিতে পারছি না। এসো। You are for the petitioner? Who is for the respondent? NBSTC? So that they appear, file the affidavit and report. Are you interested to proceed with the matter? Are you interested to proceed with the matter? Anything remains?
Only the compassionate appointment, my lord. They formed an inquiry committee. That inquiry committee, my lord, suggested that yes, he needs the my lord service. Now, my lord, all of a sudden, my lord, they offered that no permanent post would be given. You are given a contractual of the service. But that was not, my lord, accepted by the petitioner.
Petitioner is represented by learned advocate. Stop. On perusal of next paragraph, on perusal of records, it appears that video order dated 16 November 2017. A coordinate bench directed the matter to appear under the heading hearing. Stop. Matter needs to be treated as hearing matter. Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2026. Stop. Learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of this order by 10 days from date and file affidavit of service on the next day.
No, I mean March, my lord.
No. Next.
Item number 181.
I am for the petitioner, my lord. This is my exception to the report, my lord. My lord, being clarified, my lord, that order was done, my lord. My lord, initially order was passed, my lord, 2nd May 2025, my lord. My learned friend was directed to consider and pass a reason order and place before the court. That was placed before the court by way of affidavit of report, my lord. I have filed the exception and court has directed, my lord, 5th 8 2025, my lord, directed, my lord, to file an exception to the report. This is the report, my lord. My lord,
মানে কি কাঠি গুগলে সার্চ করো কাঠি
Matter was dismissed for default.
No, my lord, they are restoring. It was restored, my lord.
Proceed. Don't check. Issue. Let it appear under the heading hearing.
The only thing, my lord,
Yes.
I was wanting to indicate one fact, that there has been a prior round of litigation.
Yes.
There has been a prior round of litigation where the court has directed passing of a rescind order. When this writ petition was taken up for hearing, it appeared that the state did not comply with the order passing a rescind order in terms of the previous direction. So the liberty was granted by this court to the state respondent to pass a rescind order. Now, my lord, in terms therewith, my lord, we have passed a rescind order, which is in my report. My lord, that rescind order is not in challenge, impugned before lordship. So, my lord,
But
ideally,
that was considered by the coordinate bench.
the merits of
It was considered by the coordinate bench previously and directed matter to be heard.
that is true, my lord. Nevertheless, my lord, we find the impugned order is not in challenge before your lordship. This is why I wanted to, my lord, point out before your lordship.
There's a direction to initiate contempt proceedings if authorities fail to pass an
Right.
order.
Right.
Then this order was.
Absolutely. Now, my lord, subject to correction, he has to challenge the reason order as well, my lord.
A report was filed enclosing the reason.
Right.
So let it be decided. Yes, yes. Petitioner and state respondents are represented by learned advocates. Next paragraph. It appears that a report and exception have already been filed on behalf of the petitioner and state respondents. Stop. Matter needs to be heard finally. Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2026. Next.
We are grateful, my lord.
Item number 182.
I appeal for the response.
My lord, I consider the last order, my lord.
1st September.
I have a second division upon my COH. Here, my lord. Particularly.
Just a minute. Why is it was dismissed for default?
After that, my lord, I.
এক নয় একটা আমার কাছে নেই, আমার কাছে 14 আছে। এক নয় ডিটেল অর্ডার আছে। এক নয় ডিটেল অর্ডার আছে। সেক্রেটারি, হেলথ সেক্রেটারি ওয়েস্ট বেঙ্গলের উপরে।
Falsification test, no report till date.
Yes.
But there was a direction for filing.
Yes. পুরো ফার্স্ট সেপ্টেম্বরে সমস্তটা লেখা আছে, ওটাই পড়ছিল তখন হচ্ছে।
Issue.
At
the time of call, petitioner and Eastern Coalfields Limited are represented by learned advocates. Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2026. Next. Item number 183.
But I'm appearing on behalf of CI segment.
We are for the state respondents.
Yes,
At the time of call, petitioner and state respondents are represented by learned advocates. Text paragraph. List the matter under the heading hearing in the monthly combined list of April 2026. Next. April. Item number 184.
184, I am appearing on behalf of.
Lord, I am for the respondents. I am led by Mr. Sumit Panja. He is online. Yes, it's a hearing matter. All affidavits and everything is completed.
Affidavit in opposition, reply, everything.
Everything.
Everything is complete, my lord.
Your lordship kindly fix the matter for hearing.
Learned advocates representing petitioner and respondent authorities have submitted that affidavits are complete. Have jointly submitted that pleadings are complete.
Lordship.
Stop. Writ petition is at the hearing stage. Stop. List the matter under the heading hearing in the monthly combined list of April 2026.
Relates to the employment.
Next matter.
Lordship.
Item number 185.
Lord, I am for the respondents.
This matter, I am for the petitioner. I am led by my senior Ashish Kumar Chaudhary. I am praying for not today.
Just a minute. Wait. Let me see.
I am for the respondents.
Was there any direction for filing affidavits?
No, my lord, actually he is asking for, my lord, the retirement benefit. What has happened, the petitioner, the employee was died. We have extended the pensionary benefits and everything. Only for once of, my lord, papers that which we have already intimated. The moment they will submit, the group insurance and, my lord, other benefits will be extended.
Now, in video order dated 19 September 2023, coordinate bench directed that recorded your submission and it was observed that admissible dues of the petitioner will be processed within a period of 4 weeks.
My lord, that we have already, my lord, extended. He is getting pension and everything.
Now, what is to be paid?
Yes, my lord, the group insurance, because the employee who has died, his mother was alive or not, that he is dependent or not, that intimation we shall have to receive, then, my lord, we shall have to extend the benefit to her also. That's why you have given
Who is
issue
the petitioner? Son.
wife.
Why? So if mother is alive, then proportionate share.
Naturally, that we have intimated along with the form. The moment they will submit, we will discuss.
In that event, let it appear under the heading motion.
My lord, as your lordship.
At the time of call, at the time of call, accommodation is paid for on behalf of the petitioner on the ground of the learned advocate. Stop. However, WBSCDCL,
My lord,
West Bengal State Electricity Distribution Company Limited, within bracket WBSCDCL, is represented by learned advocate. Next paragraph lists the matter under the heading motion in the monthly combined list of April 2026.
my lord, grateful.
ওর ছাড়া কারোর নাম দেবে না জিজ্ঞেস করুন
Grateful.
Item number 186. For the state, my lord. Pursuant to lordship's court's previous direction, my lord, affidavit was required to be filed, but it has prepared, but today, my lord, it has not been brought, my lord. I will be seeking one accommodation.
Just
to appear for the petitioner, my lord, as per the last order, a hearing by the ACMOH, my lord, is directed to conduct, my lord.
So affidavit which is required to be filed in terms of order 16th
16,
October
10, 2023, my lord.
that is not.
My lord, a hearing has been given. He has furnished all the documents, but affidavit is required to be, my lord, filed before lordship. But my lord, till now, no present order has.
At the time of call, learned advocate representing the state respondents has prayed for has prayed for accommodation to file a report in the form of affidavit in terms of the order of a coordinate bench dated 16th October 2023. Stop. Time to file affidavit. Time to file a report in the form of affidavit stands extended by fortnight.
Milestone. Great.
Next paragraph lists the matter under the heading motion in the monthly combined list of April 2026.
Direct to give the advance let me court sees this, blood. If the court is thinking.
If it is serve a copy upon him, advance copy.
It will contain the reason order, my lord. That's why.
Serve a copy upon him.
No difficulty.
Because he appeared before the authority for hearing.
My lord.
Next.
Item number 187.
My lord, this is that batch of writ petition that deals with the development officers of
Yes.
IT. My lord, the matter was yesterday it was placed before, the Honorable Supreme Court, but matter could not be taken up. From the online, my learned friend can also confirm it is expected to be listed sometimes in March, tentatively showing as 10th of March. So, my lord, let this matter be spilled over.
Hand over.
spilled over in March, let's say, because.
So let it appear under the same heading. Is it at the motion stage or affidavits are complete?
My lord, the affidavits to the main writ petition is complete. At least
Complete.
we have filed our affidavit in opposition.
Have you filed your reply? Was there any direction for filing affidavits?
My lord, what has happened is that this is a 2023 writ petition wherein initially they challenged a show cause notice. Subsequent, they challenged a show cause notice. Initially, no interim order was granted. However, pursuant to that, we issued a termination notice. They filed one CAN application. There, they have got a stay. Subsequent to which, for the next year, again, the writ petitioner could not perform. We issued a fresh show cause notice, against which another CAN was filed.
Okay.
Like this, CAN 6 was for the last one. So CAN 6, my lord, has passed.
Now you have filed an affidavit in opposition in
to the
connection
main
with the
writ petition, because the
whether it was pursuant to any direction.
pursuant to a direction. I'll just indicate.
Indicate the order. Date of the order.
Yes, madam. This is the order dated 24th of April 2023. 25th of April 2023.
Just.
And then reply is also there. It too. Reply.
Issue.
My lord, they have filed reply.
Petition we have filed.
Reply.
Reply. Petitioner and Life Insurance Corporation of India are represented by learned advocates. Next paragraph. It appears from the order dated. It appears from the order dated 25th April 2023, passed by a coordinate bench on the writ petition, that direction was given upon the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Let the matter appear under the heading hearing in the monthly combined list of April 2026.
My lord, that is already there. My lord has already passed the interim orders. That is subsisting.
They are there already.
Because the LIC may
If any situation arises, you take it on an application.
And the last interim order is subsisting. That at 15th
I
July
have not
2025.
passed any order for vacating interim order. Interim order is there, it is there.
there.
Only
My lord,
the
this
nomenclature of the matter it gets changed. Now it is appearing under the heading motion, it will appear under the heading hearing.
Yeah. I'm
Yes.
so grateful.
Item number 188.
Earlier, there was an order passed by this particular matter, Lord, by which the writ petition was dismissed on the point of territorial jurisdiction. Was appealed against, and Honorable Division Bench has passed the order that will be tried.
That
Will be tried in writ petition.
appeal was allowed.
Appeal was allowed.
Serve notice upon the learned advocate representing the Union of India.
Lord, I have already served
When?
or mentioned the matter.
Today nobody is representing, no one is representing. Serve notice upon them. At the time of call, no one appears for the respondents. However, petitioner is represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocates representing Union of India. Stop. List the matter under the heading motion in the monthly combined list of March 2026. Please. Next.
Item number 189.
My lord, I'm appearing for the respondent number 2, 3, and 4. My lord.
SBI.
SBI.
Lord, I'm appearing for respondent number 1.
My lord, this is in
You are for the petitioner.
Respondent number 1.
The petitioner earlier also to dismiss for default. Reason is that my lord, when look into the order of the Honorable Judge, Justice Lavita Banerjee, passed on 27/6/2023.
So it is already dismissed for default, or it was
Earlier, again restored. But only thing is that they have also not filed the reply because they have not achieved the minimum age. That's why none of them were considered.
Was there any direction for filing affidavits?
On affidavit, report on affidavit.
Report on affidavit.
I filed it, my lord. Actually, all these persons, they did not achieve the minimum age.
At the time of call, no one appears for the petitioners and no accommodation is paid for. However, State Bank of India you are representing which
Union of India, madam.
and Union of India are represented by learned advocates. Next paragraph. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Then now.
Item number 190.
Well, item 190, I am appearing for one of the respondent number 3. My lord, my learned friend has served me a copy of the exception to the report filed by me, but I have misplaced it, my lord. I'm paying on this time, my lord.
At the
I
time,
appear
you are
on behalf of the
representing
state,
which
my lord.
respondent?
Respondent
You are for
number
the
3,
petitioner,
my lord.
Kacharia. I am for the petitioner. Which respondent?
Respondent number 3, my lord.
3.
Pashchimbangh Samagra Shiksha Mission.
Oh,
He is the main respondent. Shiksha Mission, my lord. I am the answering respondent. I filed the report.
Pashchimbangh Sarva Shiksha Mission.
Now it has been renamed as Samagra Shiksha Mission.
At the time of call, Mr. Arjun Rai Mukherjee, learned advocate representing respondent number 3 has paid for accommodation. However, petitioner and state respondents are represented by learned advocates. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading. It is at the hearing stage or motion?
Motion.
Ready for
There was no direction for everything. Only exchange of report. Your lordship kindly takes it up. File it.
Affidavit and exception.
Yes.
Next paragraph. List the matter under the heading hearing in the monthly combined list of April 2026.
Kindly, it is a
Court is not in a position to take up hearing matters. So let me see in the month of April, the matters can be taken up. Sorry. Motion means try to appreciate the predicament of this court.
My
Yes.
predicament is, my lord, that since it is a exchange of report, my lord.
Next.
Item number 191.
Yes, my lord. In this matter, I beg to appear on behalf of Union of India. My lord, this is the report in the form of an affidavit as directed. My lord, they have filed except.
My exception.
Yes.
Be careful with that.
Today you have filed?
Yes.
Oh, a record.
My lord, they have served.
The learned advocate for the petitioner has, in previous matter,
Previous.
learned advocate for the petitioner has filed an exception and same is taken on record.
My lord, my report. My lord, report I have filed, my lord.
Wait.
My lord.
Have you filed your exception? No, he's for
Yes,
the-
my lord. He told that, my learned friend told that he has filed it today, but he has served us a copy.
You are representing Union of India.
My lord.
Who is representing the petitioner?
I mean, the advocate on record is Mr. Tarun Kumar Das, my lord, advocate.
Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, Union of India is represented by learned advocate who has filed a report in the form of affidavit and same is taken on record. Next paragraph, the writ petition stands dismissed for default, parties to act on the server copy.
Item number 192.
But I am the petitioner, Madam.
Yes.
This matter, Madam, perhaps pertains to Group 3 determination. Employees Group 3, Madam. Employees Provident Fund, Funds and Miscellaneous Provisions Act.
You are representing the petitioner. So according to you, matter needs to
Since,
be
Madam, it is
treated
under-
as a group 3 matter.
It is under that act, Madam.
Issue. At the time of call, learned advocate representing the petitioner submits that the issue involved in the writ petition pertains to group 3 of classification list of different types of writ proceedings. Next paragraph, respondents are not represented today. Next paragraph. In view of such submission made on behalf of the petitioner, writ petition stands released due to want of determination. Stop. And due to want of determination, stop. Next paragraph. Learned advocate for the petitioners is granted leave to amend the presentation form and pro forma page of the writ petition and to reclassify the same as group 3 matter. Next.
Item number 193.
Also, appearing for the petitioner, also, I was allowed to bring certain documents with supplementary affidavit.
Yes.
Through supplementary affidavit, I was allowed to bring for certain documents. I have made the supplementary affidavit in July and I have served the copy to the state.
Has happened. এই এটা কিন্তু order খুলে গেছে. Has happened. You have filed your exception.
No, my lord, it requires, my lord, there are
But
some-
exception is filed exception on affidavit.
well, exception affidavit, a report I filed, they filed an exception. Supplementary, they filed supplementary.
তন্ময় চট্টোপাধ্যায়.
Yes, yes, supplementary they filed, my lord, I required. to file-
Report and exception both are filed.
They filed a supplementary affidavit. I required to file an exception to that, my lord. To the supplementary affidavit, because that requires some factual aspects, my lord.
Who is respondent number 3? Well, come back on the next date. Okay,
DM is the DM.